Item number 3. Admission item number 3.
When we pardon, my lord, item 30 of the list, my lord. My lord, the petitioner has filed one affidavit, my lord. I am there for the opposite party. I have sought for instruction.
Let
I
the
need.
matter be called.
Item 3.
Mr. Rath, you gone through the counter affidavit. They made some allegations that you have a shop.
No,
That's not correct.
That shop, Your Lordship, see, late my father's name, and I have got documents that my brother's son, nephew is managing. I am not.
So, okay.
Your Lordship permits, I can show that document. That's
No, just.
But my primary objective is safety and security. That Your Lordship may kindly take care.
Challenging the quotation call notice number 4322 dated 10/6/2024. This writ application under 226 of the Constitution has under Article 226 of the Constitution has been filed in the nature of a PIL with the following prayers. Inverted comma to admit this writ petition, bracket PIL, call for the records, and after hearing the parties, allow the same, comma, issue writ, oblique writs in the nature of certiorari, oblique mandamus, and oblique and or any other further writ, oblique direction, and set aside, oblique quash the quotation call notice number 4/222 dated 10/6/2024 issued by Puri municipality, OP number 3, and any other proceedings taken place in pursuance of the same, and further direct the opposite parties to keep the entire Bododanda free from all kind of commercial activities. The petitioner claims to be a public spirited person and a resident of Khakimoto Nuasai, Station Road, Puri. He has also stated that it is also stated in the writ petition that the petitioner had earlier approached this court in what is that number? WPC?
I'm giving that number. In a while.
No, it's here. It's only
I'm
the-
giving in my certificate.
That is in paragraph 6 of the affidavit. We have filed. That is.
No, that is there in his writ petition.
That
Just
is
so-
there in the writ petition.
WPC 10620 of 2016
That's the earlier 2016. Yes. Then
and 108 was by you or by some other
but
person?
the two persons jointly filed. Both the matters were taken up together.
And 10620 of 2016,
That is by Jitendra Kumar Sahu.
Jitendra Kumar Sahu, he's your cousin.
Not cousin, in fact.
He's a
Ah.
friend.
All right.
Friend.
And full stop, WPC number 108
Like you are my
of
friend.
2016 had been filed by one Jitendra Kumar Sahu, and both these writ applications were taken up together by this court and disposed of by a common order dated 30/6/2016, where this court had directed, that is at Annexure 5 series page. Yes, I got it, 32. Where this court had inter alia directed as follows, paragraph 12 of 13 ta quote kar debe. In course of paragraph 12, while in course of hearing, Mr. P.K. Mahanti, learned senior counsel, appearing along with advocate Mr. A. Das for Puri municipality, comma, on instruction, comma, undertakes that the municipal authority will not go for construction of any vending zone or grant any temporary or permanent license in favor of any person to have the shops on Bodadanda, inverted comma, Bodadanda, comma, which has been declared as National Highway number 203 from Sri Jagannath Temple to Gundicha Temple as per Annexure 1 to WPC number 10620 of 2016. Paragraph 13. In view of the aforesaid undertaking, since the municipal authorities are not going to have any vending zone or grant license, either permanent or temporary, for construction of any shop room on Bodadanda, which has been declared as the national highway, comma, this court is of the considered view that the undertaking so given shall be given effect to. With the above observations and directions, both the writ applications stand disposed of. He further submits that the municipality, ignoring the directions of this court, in the said judgment, the municipality has come up with quotation call notice dated 5 or 6, 10/6/2024, bracketary annexure 1, calling for sealed quotations from intending persons oblique agencies for auction of the mahal, inverted commas, the installation and operation of temporary stalls from Boda Sankha to Gundicha Temple, bracketary both sides of Grand Road during Car Festival 2024. He is apprehensive that by virtue of this, pursuant to this quotation call notice, where which quotations have already been opened on 19/6/2024, the municipality will permit opening of shops, commercial stalls on each side of.
This is the allegation.
Not allegation, admitted position, page
No
20.
commercial stuff.
Page 20.
That is a submission.
That is the allegation.
That is a submission. You will
You
say
want to
no,
show?
and we will do that. On both sides of Bodadanda, which will create hindrance to the movement of the three rathas, as well as the public who will congregate on the Bodadanda during the car festival. His further that is the main apprehension.
No, that's based on page 20, kindness.
Page 20.
Yes, page 20. Puri municipality installs commercial stalls for the purpose of revenue generation. That's their admitted position. They have wanted permission on this ground.
Acha. He submits that his apprehension is based on the letter dated 16/5/2024, which has been written by the executive officer, Puri Municipality, Puri, to the regional officer, Ministry of Road and Transport and Highways, bracketary annexure 3, asking for NOC for installation of stalls during Car Festival 2024. Full stop. In the said letter, the Puri municipality has, in the said letter, it has been stated that temporary commercial stalls are installed for the purpose of revenue generation, subject to seeking permission from the Authority of Road Transport and Highway Bhubaneswar, and that that is not relevant. Other government private NGO,
That's not relevant. That's permission.
that is for that. And that the commercial stalls will be of 15 feet width at the extreme edge of Grand Road from Bodasankha to bus stand from one side, and from Bagha Akhada Matha to Sangram Club on the other side on Grand Road, which is beyond 41 meters as per the index map of portion of Grand Road handed over to NH as per Gazette notification dated 29/10/2001. It has also been stated that some structures like barricades, this is not important. Regarding public information centers, medical aid posts.
They are permissible.
Okay. Then there is a letter to the NHI also.
Yes, NHI has permitted only those basic required stalls, public utility stalls. That is at page 22.
He further submits that the superintending engineer, NH Division Bhubaneswar, has issued NOC for installation of stalls.
With a restriction that no commercial stalls shall be erected.
Has granted permission for installation of temporary stalls on Grand Road from Bodasankha to bus stand on one side and from Bagha Akhada Matha to Sangram Club on the other side, subject to the following terms and conditions of
Correct.
NH organization as under.
Correct.
One hella, no commercial. No commercial stalls to be erected within the ROW of National Highways (Bodadanda) in respect to rules under Lands and Traffic Act 2002. Two hella, the suitable action may be taken for installation of temporary stalls after due consultation with local administration, including stakeholders, and ensure safety of road users, smooth flow of traffic on the road, and there shall not be any traffic chaos during the car festival period. Further, it is to be ensured that the damages to NH, if any, occurred during the erection of temporary structure shall be repaired to original condition, and the cost thereof shall be borne by the requisite body. So, if this is followed, you have no.
No, we have no grievance.
If this is strictly followed, you have.
We have only commercial stalls.
All right. Tell him what to say. Act. Control of National Highways Land and Traffic Act. The section.
We have said in the affidavit, we are not encroaching upon that, it's strictly following that permission. And also,
Paragraph 6 and 8.
my lord, yes, paragraph 6 and 8.
Section 24 and 38 of the Control of Highways Land and Traffic Act 2002 are as follows. It is apparent from the said provisions that permission can be accorded by the NHI subject to restrictions imposed by them. Subject to restrictions imposed by them. A counter affidavit has been filed by the opposite party number 3. Opposite party number 3, Puri municipality, stating alleging that the petitioner has, as the petitioner has a stall. Where have you alleged that he has, alleging that the petitioner is doing business of restaurant at Bodasankha, encroaching upon the Grand Road, for which he put your paragraph 11 somewhere.
Para 11.
12, I think.
11.
Is doing business of restaurant at Bodasankha, and for which he has filed this writ application and has made similar allegations earlier, as he has been cautioned time and again by the field staff of Puri municipality that he should not encroach upon the Grand Road /Bodadanda. Full stop. However, in view of the nature of relief claim, and as it would be in and as issuing directions, in view of the nature of relief claim, we are not going into the locus standi of the petitioner to maintain this PIL and dispose of the PIL with the we are not going into the allegations of the Puri municipality regarding the interest of the petitioner in filing this PIL. full stop. In while denying the allegations of the petitioner, it has been specifically stated by in the affidavit at paragraph 6. Paragraph 6 star. Instead of in the whole thing, all of the stalls are all of the stalls pursuant to quotation call notice wide annexure 1 will be installed and provided by Puri municipality through such successful auction holders for operation and displaying of activities of the government authorities and also by the municipal authorities mainly for public utilities and not for any commercial activities. Paragraph 8. That
Not
is-
encroaching the Bodhidanda also.
That I think will come below.
Yes. And we have said also strictly we are following that permission in paragraph 7.
Paragraph 8.
You have stated that someone has encroached upon the road. What prevents you from
Will-
removing that encroachment?
Yes, we'll take steps back. Because that road is maintained by the Puri municipality.
No, exactly. No. The allegations you have made.
That will, of
open
course,
to
we'll
you
take
to
this.
remove him,
We'll
if
take
he's-
the steps.
Or what steps you have taken also that you could have stated. Paragraph 8. That it is relevant to mention here for appreciation of Honorable Court that notwithstanding the Bodhidanda oblique Grand Road being declared as the national highway by the NHI to the extent of 41 meters of the width from Gundicha Temple. After this being road within Puri municipality, it is the bounden duty and responsibility of the local body. No, this is not necessary. No, 8 is not necessary. 9, I think, is necessary.
Say 9 is in tandem to 6. Same.
Eleven, 12. Para 11. 11, 12 also is not necessary. Main is where is the undertaking?
That is
Paragraph?
para 9. Then there is no further undertaking. That para 6 only.
Para 6.
Yes.
Without encroaching upon the same. All right.
9 we have stated also.
Where is it in 9?
Paragraph 9.
So, madam, that is in fact para 8 concluding part.
Para 8 I have got it.
Yes, page 4.
9 also. 9.
Para 8.
Para 8 last part.
In order to augment.
Even though such stalls are installed both sides of Grand Road, National Highway from Bodasanka without
Yes,
encroaching.
yes, yes, you're right. Say para 8 ru kardebe. They have actually mixed it with that, along with that augmentation of
Yes,
government
yes.
revenue. That is why it is confusing.
Yes.
ये पूराटा कर दियंतु पूराटा कर दियंतु paragraph 8 ଆଉ emphasis applied टा कर देबे ये जो even though such stalls that is the last sentence, even though you underline, even though such stalls are to be installed both sides of Grand Road National Highway from Bodasankha to Gudija Temple without encroaching upon the same. Full stop. It is not disputed that the national highway, that the Bodhidanda has been declared as a national highway as the National Highway 203, and it has been handed over to the Executive Engineer, National Highway Division on 17/4/2022, and the width of the Bodhidanda varies from earlier it was 39 to 41, now it is 41 to 43.
Somewhere it is 39 meters, somewhere it is 41 meters.
39
Marriage.
in the counter they have set it 43 also. From 39 to 43 in view of the undertaking in view of the decision of this court in the so and so in WPC so and so and the undertaking given by the and the permission of the NHI wide annexure 6.
That is, permission is page 22.
3 and 4.
Annexure 4 is the permission. 3 is the, 4 is the NEET type copy.
Oh, सही है क्या?
No,
Annexure 4.
both are given there actually. 4.
4.
22, na?
Right. That is,
No, that is the permission.
that's the
Asking
permission.
for permission. This is the NOC is annexure.
Annexure 4, page 22.
Yes. For the permission granted by the NHI on 4/6/2024 bracket annexure 4 and the undertaking of the Puri municipality.
Para 7, we are strictly following that.
We'll check and quote it. We are of the opinion that no interference is required in no interference is required in annexure 4.
Annexure 4 is the permission.
No, annexure 1.
Annexure 1 is the auction notice.
Interfere in view of the undertaking, we are not interfering. Because that is the quotation call notice.
But
Annexure 4 we have said in view of,
quotation, that one just, quotation call notice is contrary to the permission.
no, we are
permission-
not interfering with that because subject to this undertaking that they will not violate.
But that quotation violates the permission. That your lordship will let them confine to their undertaking.
We are not interfering with the quotation call notice, but subject to the direction that the municipality will not encroach upon the Bodadanda and will not utilize the stalls for any commercial
Commercial
activity.
purpose.
With the said observation, the writ application is disposed.
Disposed.
Needless to say, it is open to the municipality to remove any encroachment which is existing on the
Yes.
Padadanda for
Yes.
smooth movement of traffic,
Perfectly all right.
for smooth movement of traffic.
Would I suggest one sentence? Would I suggest one sentence? Subject to your lordship.
Yes, yes.
Lord, whether your lordship would like to direct the industrial authority to enforce that, to see that this is proper, subject to.
Yes, yes, yes. That is the
Mr.
duty.
That's
We don't know why
as your lordship, please.
the municipality will not ensure
Exactly, Lord, exactly.
smooth functioning of everything.
Yes,
Because it's very important and I'm repeatedly observing this.
We'll make the light.
Let us try not to bring his lordship in the court.
that's right. I'm so grateful. Deeply. Lordship must have seen yesterday news.
That stampede.
Congregation. So great.
Item number 1.
We are not referring to the decisions of Supreme Court. Let you seek instructions, and are you not well?
Yes.
You are not looking well, Mr. No.
Oh, speak.
Are you unwell? Oh, maybe that may be the
Sorry,
reason.
sorry. I just. Then I pray one thing to my Lord.
Ah.
Lord,
Paragraph
give me
50.
4 weeks time because they have to organize a meeting and.
All right. Learn counsel. For the state, learn AGA for the state seeks adjournment to seek instructions from the state on the issues which have emerged in the present writ application. So as to effectively address the court. First off, as requested, list this matter on 2 weeks,
4 weeks.
4 weeks. Paragraph 16.
Your lordship's observation yesterday,
Those
According to the
observation,
according to the contention raised in the counter, all these things, that should remain.
that will
So that
be
is
helpful.
there.
That
will
is
be
there,
helpful.
only that reference to the judgment.
To the judgments of the Supreme Court which you cited and the subsequent larger bench decision. We have,
Because that will be helpful for me to seek instruction on those points only.
yes,
which
yes,
are
so
not-
those,
So Lordship,
that
record
part,
those observations.
that part will be there.
Yes.
Only the
Obliged.
decision
I
part,
thought that this is the only order. No, it is a continuation of the order, yesterday's order.
that order which was dictated yesterday will remain except the decision part,
Obliged.
all right?
So that I can seek instruction
All
on
right.
that point
All
itself.
right. Yes, therefore, we have mentioned that.
Item number 2.
Item number 2 can take on next week. I have filed the reply yesterday. Take on next week along with I have a respondent. Take on
Because you have filed reply yesterday, therefore it should be.
only next week. Only for next week along with the reply, my lord. Only for next week along with the reply. Or tomorrow, as your lordship.
What is this matter about?
Matter relates to the challenging my appointment as Shiksha Sahat.
Shiksha Sahayak, this matter has been heard how many times?
Only for the first time. This return for the first time. Last time, my lord, condone the delay, director me to file affidavit. I have filed the affidavit, so therefore I play only either tomorrow or next week along with my reply. This was first time.
Sir, you have filed reply to what?
My lord?
You have filed reply to what?
To the writ appeal, because last time condone the delay, director to file a petition upon me. I received and accordingly I filed my.
Necessary to file a reply.
Only next week, I only filed next week, my lord,
Where is
along with
it?
my reply.
Where is the requirement of filing?
Because the document, some documents, they are not annexed to the documents, they are not annexed.
You had annexed.
Yeah, I have annexed the documents.
Sir, counsel, have they annexed any document which was not there in the writ proceeding?
That are in the writ petition, but they are not, they are not annexed.
So that is there on the court.
No, therefore I filed affidavit. Also taken next week, only next week, my lord.
Please, as requested on behalf of
Hello.
the respondent, place this matter on my.
My lord.
The submission item number 4.
My lord.
Yes.
My lord. The case of the petitioner. The order passed by the Honorable Single Judge, that is at Annexure 1, page 20, the writ petition. The writ petition filed by the petitioner were disposed of in view of that Patita Pavan Dattadas case, my lord, regarding regularization of service. So far as the petitioner is concerned, he was appointed as a daily wager, not against any sanctioned vacant post, not through any selection process. Now, he approached the Honorable Single Judge by filing a writ petition, claiming regularization against the post of sweeper.
No, whether any affidavit was filed in this case or not. Whether any affidavit was filed, counter affidavit.
Counter was filed, my. Counter was filed. Counter is at page. That is at page 53 of the brief. That is annexure 3.
Yes. Where is the decision in case of Patit Pawan?
Patita Pavan Dattadas judgment. Your lordship may kindly see annexure 4.
And except for there, where is the division bench? Achha, this has been found by the division. Yes.
This judgment of passed in case of Patita Pavan Dattadas was upheld by the division bench. Now the matter is sub judice before the Honorable Apex Court, where the contempt proceedings of this Honorable Court has been stayed, and subsequently it has been tagged to batch of cases, and dates have been fixed for hearing, my lord. So far as Patita Pavan Dattadas, that is sub judice before the Honorable Court. Now, only with respect to regularization of service, the claim placed before the Honorable Single Judge in the writ petition that the number of years, around 20 years, the petitioner has been continuing against the post of sweeper, and he claimed regularization of his service basing on a government circular, which came later in 2013. Now, my lords, in a recent judgment rendered in case of that Rabindranath Patnaik case, my lord has laid down three principles after having taken note of various pronouncement of the Supreme Court, as many as 15 judgments, my lord. So three basic requirements or ingredients for regularization. One, you should have been appointed through a valid recruitment process, a valid selection process. Number two, you must have been appointed against a sanctioned vacant post, and your continuance must be for a longer period. And five, your appointments by a valid, through valid authority, my lord. So far as this particular case is concerned,
So where is that decision?
that judgment, my lord.
Last occasion,
You had given,
yes.
Yes.
is it there?
Extremely sorry, my lord, I have
No, no, I get it online. I remember the date. It is,
one copy of the judgment.
no, no, when is the date? What is the date of
Date of the judgment, my lord,
20th or 18th?
that is on 18/6/2024.
All right.
So whether in this case any advertisement was issued?
No, my lord.
May I submit, madam? On 12/8/2002, at page 60, notification was issued by the state police headquarters for filling of vacancies in base level post. Lordship, kindly see page 60.
16 of
60 of the
60.
60, my lord.
Yes.
Government have been pleased to accord permission for filling up the vacancies in the rank of barber, dhobi, and sweeper on daily wage basis. Barber and dhobi are entitled to get the wage applicable to highly skilled workers, whereas sweeper will get the wage applicable to unskilled workers. A list of showing vacancies in the rank of barber, dhobi, and sweeper in different district and public establishment is sent here. Thereafter, last paragraph, ma'am. The vacancies in the rank of barber, dhobi, and sweeper as per the list enclosed may be filled up early on daily wage basis, and complaints be reported to this headquarters. In pursuant to this letter, petitioner was appointed.
No, where is the advertisement?
Thereafter, petitioner was working as a sweeper since 2003. In the year 2007, at page 35, another notice was issued, my lord.
Page 35.
My lord.
Yes.
Engagement of cook and vistis attendant on daily wage basis and a part-time basis sweepers at PTS Noyagarh will be done shortly against the existing vacancy, that is for 6 cooks, 4 vistis and daily wage basis and 2 sweepers part-time basis with reference to State Police Headquarters letter number 24 dated 12/3/2007. To have suitable candidates, it is decided to organize a proficiency test on 18/3/2007 morning, as number of persons may be turned up for the above purpose. As per SP headquarters letter, their engagement will not exceed 6 months at a time. Hence, they will be selected engaged for 5 months, 29 days or less. The selected cooks and visitors on daily wage basis will be paid rupees so and so respectively as per instructions. As regards engagements of part-time, so it is not clear about the monthly emoluments, what they will get, which will be intimated subsequently on getting clarification on completion of training of recruitment sepoy of this batch, their service will be terminated. Considering the facts stated above, RI is directed to collect application from the willing personnel and they must be informed about the date of holding test. They will produce their application, they must furnish the following data. As per this notice, petitioner appeared the recruitment test. Thereafter, petitioner was continuing since then as a sweeper, my lord, against the vacant, sanctioned vacant post.
Yes, then it is covered by
Your
Patita.
lordship may kindly come to page 60 once again. That is the document referred to by my learned friend. 12/8/2002.
Yes,
My lord may kindly come to the number of vacancies, page 61.
yes,
The number of vacancies in the rank of barber, dhobi, sweeper to be filled up on daily wage basis. Now, my lord may kindly come to straight away to serial number 4, Nayagarh,
yes,
barber, 1 post. But so far as dhobi and sweeper, there is no post available. This is on fact, my lord. Now, the appointment order, the engagement order, I would rather say, my lord, that is at annexure 1 of the writ appeal. That is at page 34. In pursuance to the instruction laid down in the letter dated 12/8/2002 of Special IG Police, Odisha, Cuttack, outsider Gagan Naik, son of Biren Naik, village Rajabagicha, post of Telenga Bazar, post Telenga Bazar, Purighat, Cuttack, is appointed as unskilled sweeper purely on temporary basis with effect from 22/2003. He will be terminated at any time without prior notice as and when his service is not required by the office. My lord, they have referred to this particular executive instruction that is at page 60. But however, the appointment has been given as a temporary unskilled sweeper. And my lord, have already seen that there was no sanctioned vacant post of sweeper available. That is on record, my lord. And so far as the judgment rendered by this honorable court, if my lords find at page 63, the last but third page, 7.20 paragraph, my lord has summarized the principle. 7.20.
which page?
Page 63 of the judgment, my lord, which I just now.
Yes, which page?
Page 63. At the bottom, the page marks have been given. Bottom right. Page 63. Last but third page. Para 7.20.
7.2?
20.
Yes, the middle.
May I place it? To acquire a right to the post, it is imperative that the appointee is recruited according to law, meaning thereby that he is eligible as per the recruitment rules to offer his candidature for selection and consequent appointment on a post that is appropriately advertised. He is made to face a selection process conducted by the authority constituted therefore. Then 3, upon his selection, he is appointed on a duly sanctioned post and thereafter confirmed in service after the period of probation, if any. These are the 3. Then 7.21, bearing in mind these imperatives of a valid appointment, that one needs to proceed to decide a claim for regularization in service, which, as the Supreme Court has time and again observed, is not and cannot be a source of recruitment.
Where are you reading?
That's same.
Para 7.20. I started with para 7.20. That is at page 63 of that judgment.
Page 63 of that judgment.
My lord. The last but third page, my lord.
Paragraph?
Paragraph 7.20.
Oh, this judgment.
This yes.
Download it. This is it.
Yes.
May I place it?
7
7.20. I'll place it once
Yes.
again. To acquire a right to the post, it is imperative that the appointee is recruited according
No, but
to.
should we await the decision of Supreme Court in case of Patit Pawan? Because you have been granted relief based on the decision in case of Patit Pawan.
My lord.
So, and the matter is pending. He says that it is at the stage of hearing. So
Well.
that can be done. And you are continuing,
My lord, I'm continuing.
waiting the awaiting the Supreme Court's decision in what is that?
Patita Pavan Dattadas.
No,
my lord.
in SLP, what is the number?
SLP number, my lord. It is.
Usko kato.
Give it in a slip.
State of Odisha has put to challenge in the present intra-court appeal an order dated 30/11/2021 passed in WPC number 17631 of 2020, which reads thus. Next. Learned AGA representing the state of Odisha has submitted that an SLP is pending against the decision dated 9/9/2021 passed in WPC number 19951 of 2020. No, but against that there was LPA also.
Yes,
This-
LPA number is, my lord, WA number 1086 of 2022. That Supreme Court order, that at the top it is mentioned, my lord. The LPA number is there.
The state of Odisha had preferred an intra-court appeal before this court against the said decision. Decision dated 9/9/2021 passed in WPC number 19951 of 2020, which has been dismissed by a division bench of this court by an order dated 12/4/2023 passed in WA number 1086 of 2022. Correct?
My lord. The batch
all.
of cases.
22 and batch of cases. The state of Odisha has preferred special leave to appeal, giving rise to SLP number 16949 of 2023 and
batch of SLPs.
batch of SLPs against the said judgment of the division bench dated 12/4/2023 in WA number 1086 of 2022. Full stop. Next. Since the respondent has been granted relief solely based on the decision based on an order dated 9/9/2021 passed in WPC number 19951 of 2020, in the facts and circumstances noted above, the receipt appeal is adjourned to 8 weeks awaiting Supreme Court's decision.
Item number 5.
May I please, your lordships?
Yes.
My lord, I have challenged the order passed by the Honorable Single Judge, your lordships, dated 24/8/2022. Subsequently, review was filed and that was rejected under Annexure 4. That is, your lordships, order dated 27/3/2023. Lordship, I do not know whether the OA number 50 of 2018, which is subsequently my lord renumbered as WPC OA number 50 of 2018, whether it is before your lordships or not. That will, my lord, give the facts to your lordships. What has happened, my lord, the petitioner was appointed as additional class teacher in Hindi on 27/9/90 by the managing committee. And for approval of her appointment, but it was sent by the director, by the circle inspector of schools to the director. It was not approved, for which your lordships, the petition, the appellant, present appellant, filed one OA because jurisdiction by that time was before the State Administrative Tribunal.
Mr. Counsel, what is the illegality in the order?
My lord, I am just saying, my lord. The act came into force in the year 1989. But the rules, there was no rules by that time. Rule came in the year 1992. So, only direction was given by the State Administrative Tribunal to the government to consider the similar situated person, one Chaturbhuja Patra, whose appointment was approved. So, therefore, the case of the applicant may be considered, considering the case of Chaturbhuja Patra.
Who are you?
I am on class teacher, additional class teacher.
Where?
My appointment was on 27/9/90
Where?
in my lord Tulasipur, in Tulasipur ME school.
Who appointed you?
The managing committee.
Under which provision?
Managing committee, my lord, the provision is a 1974 rules.
1974.
Rules. Managing committee is also empowered to give appointment by that time.
Before your appointment, the ordinance was promulgated in 1990. Is correct or not?
Oh, my lord, by that time it was continuing. My humble submission with lordship.
What was continuing?
1974 rules continuing because 1992 rules didn't come into force. 92 rules came into force.
Let us see the ordinance. Where is the ordinance?
Ordinance, my lord, it is quoted in the order. Your
And
lordship,
ordinance continued till
Ordinance, my lord, 14th August 1989, the ordinance came into force. Your lordship may straightway come to
14th
page
August
27. 1989,
1989,
my lord,
the ordinance
my lord,
was promulgated.
my lord.
Then
But my lord, rules didn't come.
when were you appointed?
90, your lordships.
When?
That is my 27/9/90.
27/9/90.
90.
And this ordinance continued till when?
No, my lord, it is continuing,
Continuing.
my lord,
It is continuing.
my lord. The act,
It has become act.
yes,
When?
that my lord, I don't have. Act, my lord. 93, 93, 93.
Until 1993, this ordinance was operational.
But ordinance basically it is operational for 6 months. And it has to be presented before the assembly within a period of 6 months. And if it takes the shape of an act. But my lord, regarding the query made by this honorable court, then I'll have to take instruction and because
No, let us see, where is the act?
act, your lordship, 7B of the act.
Sir, where is the act? Act, that may demonstrate something.
Yes.
Something can be discerned from the provisions of the act.
Act,
When was the ordinance
Ori-
promulgated, then when it was extended, whether it was extended or not?
Orissa Education Act 1969.
Yeah. Education manual. Or if there was a fresh ordinance, so that.
At page 136 of that book, my lord. Page 136. The provision is 7B.
That is 5 years. Whether there was this ordinance was there. Do you have a copy of this amendment act? Odisha Act 14 of 1993?
Sub-rule 2 of 7B was incorporated by way of amendment. That is Odisha Act 14 of 1993.
Where is that Odisha Act 14 of?
That is. Lordship, keep it to tomorrow, then I can come with the counter affidavit.
That is in the Odisha Education Amendment Act.
No, that is something else.
That amendment that substituted by Odisha Act number 14 of
No,
1990.
Odisha Act number 14 of this 1993 is something else.
That is with respect to the substitution of subsection 2 of section 7B.
No, that will come in this.
But so far as that ordinance is concerned, then I'll have to produce it.
All right.
I'll produce it.
7A is there in the Odisha Act 14 of 1993. 7A is there.
7B, how 7B was added?
Yes. That I'll have to produce.
Was that Odisha Act 14 of 1993?
That is with respect
Yes, 1990, 1989. It was amended in 1989.
by way of ordinance.
No, by Act. Act 15 of 1989.
ಅದನ್ನೇ ಪ್ರಿಂಟ್ ಔಟ್ ಮಾಡಿ ಬೇಡ. Save for them too. Save for them. I'll change it. Okay, তারপরে print out করে।
Yes, so it was, the Act was enacted in 1989.
But there was no rule, your lordship. There was
So-
no rule. If there is no rule, your lordship, the
Ah.
appointment will be made by virtue of a rule.
Already.
1992. Rule came into force in the year 1992.
All right. That's all.
My lord, Act came into force in the 99. Yeah, my direction was given by the State Administrative Tribunal to my lord, the state government, actually to consider the whether on the basis of the appointment made in the similar situated person.
Mr. Similarly situated person was acquitted in a theft case, therefore everyone should be acquitted in a theft case.
No, I am not saying so. There was a direction by the honorable tribunal.
There cannot be such, even if there was such direction, the question is, the court will not, I repeatedly say this, that the court will not follow illegality. If something was illegal, that was illegal.
I am not, my lord, saying that my
The
submission
question is whether your appointment was in accordance with the act or not. That is the only question.
But my lord, whenever act is there, procedure, your lordship may see the language which is used in 7B.
Yes.
Page 27, your lordship may kindly see. The state government or any officer or authority authorized by it may prescribe the qualification to be possessed by persons for appointment as teachers, including the norms relating to the recruitment of such teachers in different categories of private educational institutions. But I am eligible,
Yes.
having requisite qualifications. Every private educational institution shall, in order to be recognized by the state government, appoint the required number of qualified teachers as provided in subsection 1 from out of the list of the candidates select for this purpose by the selection board constituted under subsection 2 of section 10 in the prescribed manner. So the prescribed manner is manner in the rule. Rule selection board is constituted in the year 92. By that time, there was no selection board. So my lord, unless and until my lord rule came into force, my appointment cannot be said to be illegal.
All right.
That the prescribed mode is your lordship will be my lord by virtue of a rule.
We understand that.
So whenever there was no rule at all,
So
then
therefore, despite the act which was enacted in 1989, you were required to be appointed or you could be appointed under the previous provisions because the rules were there.
yes,
This is your submission.
yes.
Wrong.
And there is also a judgment to that respect.
Yes.
There is also a judgment to that respect. Your lordship. Judgment according to
Yes, act, it's not visible. I don't, ulta seedha, please give me the stapler. Yeah.
We can provide you a table lamp and table everything in the courtroom. Is this the place to prepare?
No, my lord, I have just kept here, my lord. I'm sorry, my lord. I have kept the judgments. What it was left anyway. I am sorry, your lordship. Nineteen 1993.
Please properly page it.
Your lordship, just para to the facts, my lord, I want to my lord place before lordships and the conclusion part there.
What is the law laid down?
Please.
Here, my lord, the subject matter is same. Your lordship may kindly see the my lord page 252. Managing committee, my lord, by that time appointed the in 93.
Yes.
Your lordship may kindly see the page 252. My case is similar to that.
Yes.
Coming to the second question as to whether the petitioner's appointment were in accordance with the provisions of law or not. But earlier, my lord, in para 2, my lord, your lordship will find these additional class teachers were appointed by the managing committee. It is seen that admittedly the petitioners didn't have requisite qualification at the time of appointment, but subsequently they acquired qualification in the year 1991, 92, 96 respectively. In this connection, reference may be made to Annexure B by 4 attached to the affidavit filed by the Inspector of Schools Puri. Said annexure is a circular indicating decisions of the state government for approval of posts of additional section teachers. The petitioner is additional section teacher, your lords, is non-government aided high schools of the state. The letter written by the Deputy Secretary indicates that the state government was pleased to approve post of additional section teachers with effect from 7/6/1994. In the schools, as per the list enclosed, provided continuance of such posts are found justified as on 7/6/1994 on the basis of yardstick and roll strength of each school. While considering the approval of appointment such additional section teachers, the following criteria may be observed.
Why are you referring to that? The London single judge has referred to section 7B of the act and has
But these
Bill.
teachers were appointed after 1989.
whether this aspect was considered in this case.
No,
Why are you lying?
because my case is squarely covered by this judgment.
Squarely covered by, your case is not squarely covered by that judgment because in this case, London single judge has specifically referred to section 7B.
Right.
Whether section 7B was considered in this decision.
That is my
That is the
teachers,
question.
but that is not in respect of additional class teachers. The appellant is an additional class teacher, your lordship. His appointment will be considered, my lord, as per the rules. My case is, my lord, I am on additional class teachers. Even if after appointment of 1989, my case can be considered because management.
Is this your
My lord,
submission?
my lord, your lordship may consider this. Why, my lord, the honorable single judge has not considered? For the reason that my appointment was made by the managing committee. In the year 1989, whenever Act came into force, only appointment can be made by the selection board. But here the additional class teachers can be appointed after 89 also by the managing committee.
Even today, managing committee can appoint.
Well, that state will be.
No, you say, you are raising legal question.
But
Additional,
class teachers, my lord, can be appointed by the managing.
even today.
My lord.
This decision, this point we shall consider and decide. Additional class teacher.
My lord.
Very good. Where is that position proposed? Where is that post, additional class teacher? Where is the post of additional class teacher?
Additional class teacher, my lord, as per the yardstick. But if student strength will be more,
So from which document can we get that the roll stand justified appointment of additional teacher? Is it there on record?
no, that is not disputed. That is not
You
disputed.
can be appointed by the managing committee, but managing committee will pay you. You will not be entitled for, your post will not be entitled for any grant in it.
You will also keep it tomorrow, my lord, so that I will also keep it tomorrow. I will my lord apprise to your lordship about this, the law and appointment of additional class teachers and all these things.
Fine.
The law relating to that. You also keep it tomorrow.
Have you taken that point in your appeal, memo of appeal? The appellant
You also keep it to tomorrow, your lordship.
in the appeal has put to challenge dated 24/8/2022 passed by a learned single judge of this court in WPC bracketed OA number 50 of 2018. Full stop. Next. In nutshell, comma, the facts of the case are that the petitioner was appointed as an additional section teacher, comma, Hindi bracketed COVID, Covida, class 8B on 27/9/90 by the managing committee of Tulsipur ME School, comma, Nimapada. Stop. The said school was an aided educational institution within the meaning of section 3B of the Odisha Education Act 1969. Stop. The school was later taken over by the state government on 1st of April 1991. Stop. The service of the petitioner was not approved and accordingly not taken over, mainly on the ground that his appointment was not in accordance with section 7 capital B of the Odisha Education Act of the Act of 1969, in as much as by virtue of the said provision, in as much as, comma, after coming into, after insertion of section 7, capital B of the Act pursuant to amendment in 1989, comma, only selection board where is that selection board?
92 rules, my lord.
Tell me.
92 rules.
No, no problem. Which prescribe that every private educational institution prescribes institutions shall appoint qualified teachers and non-teaching staff by making selection in accordance with the procedure and criteria prescribed by the state government. Stop. The petitioner was appointed by the managing committee, comma, as has been noticed above. First off, the respondent, the appellant. The appellant had approached the Odisha Administrative Tribunal, aggrieved by non-inclusion of his name as approved teachers of the school, giving rise to OA number 3417 bracketed C of 2003. Stop. The said application was disposed of with a direction to consider the appellant's case by passing a reasoned order. Stop. The appellant's case was rejected by an order dated 35/2015, assailing which the appellant filed another original application giving rise to OA number 1824 of 2015. Stop. The tribunal again directed the government to reconsider the appellant's case, appellant's grievance. Stop. The appellant's representation, appellant's case or claim was again rejected by an order dated 10/11/2017. Stop. The appellant thereafter
There, my lord, by that order, my lord, it was directed to consider was the case of the applicant. The case of the Chaturabhuja Patra has not been taken into consideration. As the case of Chaturabhuja Patra.
case of the applicant, keeping in mind the case of one of the teachers, namely
Chaturabhuja Patra, your lordship.
Chaturbhuj Patra, whose services were approved, who was similarly situated and whose services were approved. Stop. The said order dated 10/11/2017 came to be assailed by the appellant by filing yet another original application before this Odisha Administrative Tribunal giving rise to OA number 50 of 2018. So stop. Consequent upon abolition of the Odisha Administrative Tribunal, the said original application is to transfer to this court and came to be registered as WPC bracketed OA number 50 of 2018. So stop. In the, it is apparent from the impugned order passed by the learned single judge that the appellant took specific plea that her case was on similar footing with one Chaturbhuj, with the said Chaturbhuj Patra, comma, an additional section teacher class 6B of Lathipada UP school under the DI of schools Naigad, who was appointed on 7/10/1988 and subsequently his service was taken over, comma, being approved by the authority. So stop. Next. The said plea, learned single judge also noted the fact that the appellant's claim was rejected on the ground that the appellant's case was distinguished from the case of Chaturbhuj Patra on the ground that his date of appointment was prior to coming into force of the ordinance dated 14/8/1989. So stop. Next. That has been distinguished, Mr. Counsel. Next, learned counsel appearing on behalf of the appellant has submitted that before that after insertion of section 7B in the Odisha Education Act 1969, comma, no rules were framed. And rules came to be framed only in 1992. So stop. In accordance with the rules of 1992, the appointments were to be made based on the recommendation of the selection board. So stop. He submits that prior to coming into force of the 1992 rules, comma, the 1972 rules, 1974, what is the name of the rules?
The Odisha Education Recruitment and Conditions of Service of Teachers and Members of the Staff of Aided Educational Institutions, Rules 1970.
Sir, Counsel, in 74 rules.
page 976.
Rule,
That 1974 rules as my.
Mr. Rule is not important.
Well,
See, you will have to see the events, how the
Yes.
act was amended.
but
First of all, the ordinance came.
yes,
In the ordinance, the provision was something else. Then the act came. In the act, there was same provision as was there in the ordinance.
Yes.
And thereafter, again, there was some amendment. So you see, there is no reference to any selection board. Please see. Have you seen?
Yes, ma'am.
Where is that? You must be having the old book.
I've got that also. It print out there. Has only been changed 5 years to 3 years. Yes. इसमें है ये
sub-rule 2 of section 10, my lord.
Selection. This was added.
This is not there. No, every regulation. It is not in what? এটা প্রিন্ট আউট করলে तो नहीं अच्छा, okay. No. Substitute. In section 7, after the words 1 year, the words 2 years shall be substituted. Oh, अच्छा. 7B में there is no amendment. कभी-कभी mistake होता है.
We cannot rely on this, the publication. Rule. Prior to coming, that before insertion of section 7 capital B in the Odisha Education Act, rules laying down the procedure for appointment as additional class teacher were applicable. First off, he contends that the said rules were applicable despite insertion of section 7 capital B of the Act. First off, we do not find any force in the said submission on behalf of the appellant. Section 7B of the Act reads as under stop. The Act in no uncertain terms prescribes that the private educational institutions shall in order to be recognized by the state government, appoint required number of qualified teachers as provided in subsection 1 from out of the list of candidates selected for this purpose by a selection board for the state or the concerned district as the case may be, constituted under subsection 2 of section 10 in the prescribed manner. Most of the appellant was appointed by the governing body or what? Managing committee. Managing committee, and not in accordance with the statutory provision under section 7, capital B of the Act, comma, we do not find any reason to interfere with the impugned order passed by the London single judge. This appeal has no merit and is accordingly dismissed. So now should we give second last?
No, my lord, not second last. What happened, my lord? In a similar case, counter has been filed. In a similar case, counter has been filed, whether it will be adopted or not. I'll take instruction to that effect. You'll also call this matter
What
next
is this
week.
matter about?
This is the Virus Act is under challenge.
Virus, there is no affidavit.
Is this the only case on this?
No. 2, 3, 4 cases are there. In one case, that they have finalized that draft of counter.
No, one is finalization of a draft, but if 3, 4 cases are there,
3, 4 cases.
better if they heard together.
Yes.
Every day we can't decide.
No.
the same thing.
That's what I'm saying.
Provided, of course, it's ready. Because if they're different councils, they may want to address the court.
Yes, ma'am.
Do you have the numbers or you don't have?
One number is with me. That is WPC.
Mr. Biswal, do you have any idea if any other cases? are
No,
pending?
Your Lordship. Even I will inquire about the other matters. If Your Lordship permit, I can provide that numbers during the lunch time. Before 2, I can provide that numbers if Your Lordship will want that.
No, what are the grounds? Challenge.
And that's because the state didn't file the counter affidavit, I'm not prepared fully.
No, why counter affidavit? No, facts are required to be addressed.
My lords.
When you put any statutory provision to challenge, then the grounds are limited. You have stated so many facts.
My lords.
What are the grounds?
If we call it next week, I can.
Same rule is under challenge, same
11.
provision. It is under challenge in other cases.
Yes, Your Lordship.
Are you seriously challenging the rule or mostly it is
Only
on?
particular rule 11, Your Lordship. Because there is a discrimination between 2 class of employees who are homogeneous in nature. Those are homogeneous in nature. The mode of appointment is same, but the one class is discriminated for promotion. On that ground, we have challenged the rule, Your Lordship.
Let us see, where is that?
Eligibility for promotion.
Where is that?
And it's at page 73, but Your Lordship will excuse me for the day, Your Lordship. But I have not prepared it fully. But I know the matter. But to assist Your Lordship, I have to.
No, we are just looking
My
to see
lords.
what is the
My
nature of challenge. Because if you look at the section, if you are pointing out something, we can make out if.
Page 73, Your Lordship, Rule 11. Eligibility for promotion.
Yes, rule 11, what is there?
Yes, Your Lordship. Your Lordship, kindly see Rule 1, 11.1.
Yes,
In order to be eligible for promotion to the post belonging to level 5B of the service,
level
The-
4.
level 5B, Your Lordship.
No,
11.1. I'm at 1.
Yes, one.
Yes, level 5B of the service.
Where are it? Which?
The second line of the Rule
No,
1.
just a minute. Then we are looking at a different page.
I'm at page 73.
73.
My lord is looking at the page 40, that is the original rule.
That's a 1999.
Okay, so this
No, it
is
doesn't
the
have-
amended rule. Okay, sorry. Okay. 73.
My lords.
Yes.
Yes.
I'm at 11, rule 11, your lordship. In order to be eligible for promotion to the post belonging to level 5 VB of the service, the candidates must have served for continuous.
You are reading?
At rule 11, your lordship, 11.1.
Yes.
In order to be eligible for promotion to the post belonging to level 5B of the service, the candidates must have served for a continuous period of 4 years in the post belonging to level 5A of the service, provided that, this is important, your lordship. Now they have bifurcated two segments. 50% will be
Yes.
50% will be promoted to the post of headmaster, and the rest 50% they will be.
Well, no, there is no word master.
Where first?
I'm coming to that, your lordship. Your lordship, kindly see provided rule 1.
Yes.
50% of the vacancies shall be filled up by the candidates having passed high school certificate or higher secondary examination or graduation with secondary teachers training certified teachers course, diploma in elementary education from any recognized board or university or equivalent thereof, and have passed Orissa teachers eligibility test 1. So candidates engaged as Shiksha Sahayak or junior teacher contractual against the advertisement published after 11 to 13. These are first class of employees. Second, 50% of the vacancies shall be filled up by the candidates possessing a bachelor degree in any discipline with secondary teachers training certified teachers course, diploma in elementary education or bachelor in education or an equivalent examination and training course from a recognized board or university and having passed Odisha teachers eligibility test 2. So candidates engaged as Shiksha Sahayak or junior teacher contractual against the advertisement published after 11 to 2011. The distinction is, your lordship.
So this is the provision which you are challenging,
Yes, your lordship.
this proviso.
Not proviso, your lordship. Coming to that, I'm just
No,
explaining.
no, tell us what are you aggrieved by?
My lords, your lordship may kindly come to.
Thereafter, not this.
I'm obliged. I'm obliged. Thereafter, in 2, in order to be, this is important, your lordship, in order to be eligible for promotion to the post of headmaster, headmistress of the government primary schools in level 4 of the service, candidate must have passed high school certificate or higher secondary +2 examination or graduation with secondary teachers training, certified teachers course, diploma in elementary education or bachelor in education, and must have served for a continuous period of 2 years in the post belonging to level 5B of the service. Next, your lordship, Roman 2, in order to be eligible for promotion to the post of graduate teachers in government upper primary schools in level 4 of service, a candidate must have possessed a bachelor degree in any discipline or an equivalent examination with secondary teachers training or certified teachers course or diploma in elementary education or a bachelor in education and must have served for a continuous period of 2 years in the post belonging to level 5B of the service, provided that in case of non-availability of the adequate numbers of persons for promotion to level 4 of the service, 6 years of service in level 5A and 5B shall be taken together for consideration of promotion, but must have rendered at least 1 year service in level 5B. Your lordship may kindly now resurrect with that proviso. The first proviso, 50% per teachers who have +2 qualified, they will be adjusted against the headmaster, headmistress post. The remaining 50%, they will be appointed against the graduate teacher post in level 5B. Now that being so, you should kindly go to rule 3 now. 11.3.
Yes.
If I am factually correct, your lordship, the first set of teachers, they will be headmaster in a lower primary school, and the second set of teachers who have bachelor in their bachelor degree, they will be appointed against the graduate teacher post. Now in level 3, in order to be eligible for promotion to the post of senior headmaster in government primary school in level 3 of the service, a candidate must have passed high school certificate of or higher secondary +2 examination or bachelor degree in any discipline with secondary teachers training or certified teachers course or diploma in elementary education or bachelor in education or an equivalent examination and must have served for a continuous period of 2 years in the post of headmaster of government primary school belonging to level 4 of the service. This is for government primary school, your lordship. Rule 3, second line. You should mark that, because that is also very confusing. That is for government primary school in level 3. So far as Roman 2 is concerned of Rule 3, in order to be eligible for promotion to the post of headmaster in government upper primary school in level 3 of the service, a candidate must have
Just a
obtained
minute. So you are challenging which provision?
Rule 3, Your Lordship. 11.3. Because in 11.3, so far the present
Just a
petitioners are
minute, just a
concerned.
minute. So this 3 has nothing to do with the proviso 1.
It has, Your Lordship. Because why I'm saying so? Because under the proviso, they have bifurcated assistant teachers in 2 categories. One being who are +2 passed, and second being who have a bachelor in their degree.
Mr. 1 will not apply in your case because that deals with promotion to 5B only.
Yes, Your Lordship.
All right.
But in 5B, there are 2 categories. In 5B, there are 2 categories, Your Lordship.
5, there are 2 categories,
lord.
but when you are challenging Rule 3 deals with promotion to the post of senior headmaster in government school in level 3.
My
This
lord.
has nothing to do with 5B.
Your Lordship, perhaps I was not clear. Perhaps I was not clear, Your Lordship.
Yes.
Unless and until under 5B, if I have +2, if I have +2 CT in my course, I can only be promoted to senior headmaster in primary school. In the case I will be promoted to the post of graduate teacher, I can be promoted to the post of principal in upper primary high school, and subsequently I can also be promoted to the post of block education officer and senior block education officer. The hierarchy of promotion with regard to that graduate teachers is more than the present petitioners. Even though present petitioners have the bachelor degrees, but they have not been promoted to the post of graduate teachers. They are confined to the post of the +2 CT teachers.
Why?
That is the main reason is for change the virus, Your Lordship. That is the main distinction here.
Where are the other cases pending?
Okay, give it by 2 p.m. You said or he said? Who said?
Where are the other cases pending?
That one WPC 17780 of 2023. And other cases, I will give the number. One material was also hearing that matter.
This week, after vacation or before?
After vacation, I will also give that number.
These matters should not remain pending.
No, my big.
The
May this matter next week. Even in absence of the counter, I will argue this matter.
no, you can argue this matter, but
Unnecessarily, why should the other
No,
matters also remain pending?
I am saying submitting, but I have written 3 letters. No counter has been filed in this case because virus of the act is under challenge.
no, where is the rule?
Rule is under challenge.
Yes.
If they can establish their fundamental rights is violated, then I can argue on that matter on merit on election. Fix it next week. If no counter is filed, I will argue this matter.
Even if.
Matter. I'll try counter will be filed by Monday.
The constitution.
This food. Beat up failure.
Basically, you are agreed by that amending act of 2019.
My lords, I'm grateful.
Amending Act of
2019, which has amended the rules.
Rule.
amending rule.
Yes. I'm sorry, no.
As requested on behalf of the estate, list this matter on next week.
My lord, may I pray next week on 11th because some holiday on 11th.
11th is holiday.
No. I am praying for 11th because
11th.
Ratha Yatra is that. So
11th.
I'm grateful.
Rath Yatra this time is for 2 days.
I may not be on my age. So for that reason, I am.
But
praying.
you don't have any, don't have an advocate general. What is the? There is a vacuum. It's a constitutional vacuum. Why? It is also for the members of the bar.
Yeah.
You're saying something about the Advocate General?
No, my lord. And not on this point, on the point involved in this case.
You have on a case, give that number. You have a case or you want to address the court?
My lord, that batch of matter, my lord, was heard, my lord, matter, and on their request, matter was posted to some authority.
Exactly, that is what you tell us.
But,
What a number zone.
but हम दे दिए.
Daily
Yes, you
ka
were
same
arguing,
sir.
Mr. Kant. You
I have-
were arguing
That
the
is what
matter.
he's saying, he's not able to.
I have
remember
given
the
that
name.
number.
At the launch, my lord, I will provide all the numbers.
You have the
have
number.
I have given that number.
It
One.
is in the list, my lord.
17780.
The item 15.
All right.
Yes, come.
17780.
Item
Yes, sir.
15 today,
No, my lord, not today.
for that day.
That is adjourned to past July.
Along with so and so.
So leading case is 10430.
Okay, it was adjourned to Friday.
Right.
Monday. So when we adjourn this, we can tag that.
This matter will be tagged with that.
Yes.
If I associate. You also know.
10430.
This matter is concerned, very like man.
10430 of
10, 20 years
2022.
back,
Yes.
only the advocate
24.
general address the court.
23 years.
If highly see challenge.
No, if virus of an act is under challenge, then under the scheme of the constitution, copy of the notice is to be served upon the advocate.
Advocate general.
One aspect, but
Our practice, as you also know, usually advocate general used to address in the various matters.
No, that
So
because
that
of
is
this,
what-
because of this only.
Honorable Chief Justice in fact hinted that. Because that.
I'm worried, Mr. I'm worried more about
I'm going to
that you
let's
don't
flip
raise
letter.
any such issues. You raise so many, remove encroachment and this and that. And
Slip
what is
letter,
this? You
Matthew.
don't have advocate general for so long. So, there's a vacuum. And that is the requirement mandate of the constitution. It is not that, it's not an ordinary position.
The
functioning of the courts get affected because of that. This is unfortunate. Yes.
So this you have posted to which day?
Posted to 11, along with that.
Along with 10430. 17780.
Yes.
Is part of that.
What? Analogous matters.
I'm grateful.
Item 7 will call at book end.
Item number 8.
Lordships, we are supposed to get instructions on this matter. Yesterday, they took time to get instructions.
Yes, ma'am. I have got the instruction that management has not been approved. They have not submitted any proposal, my lord.
Item 8. What is this about?
Your Lordships, it is that matter where the
in charge principal, vice principal. He is issued with a suspension and also a show cause for disciplinary action. And both were challenged before the single bench on the ground of lack of jurisdiction, that particular secretary did not have the authority to do so. I ultimately did win the matter before the single judge. But what the single judge said is this, because that was one of the contentions of the government of the state, that if he lacks jurisdiction, then all your promotional avenues which you have got till date is also bad. And so while granting me the relief, they demoted me to the post of lecturer, my initial post, which means today I'll get a salary of 2,200 from some 60,000 to 2,200. I'm about to retire. So, but there was a finding in the court that you constitute that governing body and take up his promotion so that everything can be regularized. Now, so much of time has passed. I have challenged that order where I'm asked to join as a lecturer. But I think it was also incumbent on their part to immediately formulate that the whole thing would have solved.
So that Odia proverb applies to you. That Mr. Das had gone, right? You keep on challenging that, ultimately everything.
I say, but this is a very precarious 2,200. I mean, it's less than even a laborer gets today. Unskilled labor gets today in a month. And I've served, I've discharged.
No, but is there any order that the salary paid to you will be refunded or something? That is not there.
No. But I go back to that original post. So original post at that time, the pay scale was 2,200. Actually, even that should not be done, but that's what they're offering.
The old pay scale.
Yes. You'll also just look at para 8.2 at page 24.
Yes.
Yes, ma'am, I have got the instruction. Let's see my love. Honorable single judge order, ma'am.
Now, what is your instruction? Whether the-
Instruction, my lord, the governing body has not furnished any proposal for reconstitution or for approval. Accordingly, we have issued 3 letters. May I submit, my lord, your lordship may see. After order of the honorable single judge, 3 letters were issued to submit the proposal so that lordship may see.
I think there's some provision. If they don't do it, you can.
There is no governing body.
No.
A private, complete record,
Oh.
private institution. It's
That is why your Lordship, we were suggesting for notices to respondent number 3. It is then.
Which respondent?
3, your Lordships, that college.
And
the very
notice may be-
college which is under 2.
Notice may be issued
Which
to
is
the
under 2.
Issue notice.
You will accept notice for 1 and 2.
for 1.
That's not. Yes.
And for 1 and 2 only. 1, 2, 4.
Item 9.
Let's say we have an interim prayer. If this judgment is stayed, at least I will not be
Let
forced to
us
join.
see. Let's see. Let the
Now, I'm only to this extent that I will not be forced to join. They might take an action against me that you're not joining.
the difficulty is that you challenged your order of suspension.
I know,
of
this is right.
So that order has been given to you. All right, that has been applied in your case with full force. So now we are thinking of constitution of a governing body. The college is not responding.
Yes.
So let us see.
I'll take my chance at this.
Yes.
Let them appear. I'll take.
See,
1,200.
So what?
Lordship.
If you don't join, then you
They
will be
might
a
take
loser.
some actions against me. That's the whole.
So.
Lordship,
do that.
Lordship, I shall give that instructions.
Join without prejudice.
Yes.
You can join
Without prejudice.
Item number 9.
Before my seniors to begin, Malad, may I pray, Malad, item 9 and 24, the impugned judgment is the common, where I am the caveat petitioner in 24, and all the petitioners, all the batch, Malad, they were the opposite party before the non-rule single judge. And the judgment which was passed, that is under challenge by the item 9 and 24. Let them solve copy, Malad, 1. Let them solve the two cases, Malad. They have not solved the copy.
Sir, my copy in course of the day.
Yes, ma'am.
In the course of the day, we'll start the copy.
Thank you, sir.
Accept notice on behalf of.
9, opposite party.
I am in opposite party number. In this first case, opposite party number 4, 5, and 6. Respondent 4, 5, 6.
Okay.
How many appeals are there? 1, 9 and 24.
Malad?
9 is. He's
3
already-
cases, 4 cases, and 24 is the one case.
he's already appealed.
24, who is appearing?
I am appealing.
So you also, sir?
But there is the delay of 4 days, I have to condone that.
Condone.
I'll serve the copy.
Who's it?
24 second copy.
Second case,
Second copy filed on the division bench.
Respondents number 4, 5, and 6.
State appeal? 24 to state appeal?
First one. 4, 5, and 6. 1, 2, 3, who appears?
State, I guess.
State.
Just check, Mr.
Yes, ma'am.
Check and inform us in each case.
In 1, 2, 3,
Yes.
state.
1, 2, and 3. Stop. Next.
1 to 1, 5.
WA number 24. IA number 24. This matter has been taken up with the above noted cases as the same order passed by the single judge is under challenge in the present appeal. So there is delay of 8 days in preferring the appeal, which is condoned. IA so and so, and hold on. Let copies of the memos of appeal is served upon learned Mr. So and so
Mahendra Kumar Sahu.
in course of the by tomorrow.
By 2.
So, Mr. Sahu, you are there in all the connected appeals.
Yes, Malad.
List these
All the
matters.
connected appeal.
List these matters. Mr. Sahu, so and so accepts notice on second one. Accepts notice on behalf of
On behalf of Malad.
Private opposite party or sir.
4 to 6, sir.
Yes, ma'am.
private respondents. So list all these matters on when?
Malad.
1 week?
Malad, next week, your lordship may, any day, Malad, your lordship. Oh, 1 week after, yes, your lordship.
1 week.
After.
Along with a copy of IA also, my lord. We'll serve copy along with IA.
IA for
Miss case. Interim order of stay of operation of the judgment, you also say that let the notice be.
it appeals and other pleadings.
22 तेईस order open आते
So, performer responded, no need to take notice. You have some performer responded.
Will it be possible, my lord, to take it up with the week commence in 22nd?
You decide.
Let's keep it to 22nd. We have not. Yes, my lord. Let's keep it. My friend has some problem.
When?
20, we commencing from 22nd.
24th.
24.
Yes.
I think the respondents are different. We'll check and see. The parties are different, you are sure?
They were
Puri?
petitioner before
No,
this.
that's not right. Because they are different, I'm asking, you have instructions to appear for all of them.
Yes, madam. Because
Okay.
I was the counsel for the all petitioners.
One there only. Four and five.
Performer respondent.
No, no, but not for the pro forma respondent.
Exactly, that is what I'm.
Private respondent, not for the pro forma respondent. And pro forma respondents are the, suppose in one case, they were the respondent before the, sorry, opposite party before the single judge, but other opposite party has been made in their respective appeal as pro forma respondent.
Item number 10.
This matter relates to that medicines of matter. Your lordship is going to hear this matter at say 2 o'clock. This minute.
Item 11.
Item.
Fixed to 2 o'clock. My friend was telling me because the advocate general is not there.
That your lordship may remember that case that regarding that
We'll
option.
see at 2 p.m.
Okay, okay. Yeah.
My-
Item 11. Item number 11.
We may take so moto notice.
Mr. Khuntia, you call Mr. Patnaik.
I'll
Milos, item number 11, I'm to
Call
DC
Mr.
Milos. I
Patnaik
am
because we propose to pass an order.
That will be very embarrassing for everyone.
Mr. Patnaik will remain at 2 p.m.
Yes.
Milos, am I audible, Milos? Milos, am I audible?
Yes, please.
Milos, in item 11, it may be fixed at 2 Milos because it is a similar item as of 7 Milos.
All right. 10, 11 are same.
Milos, I may be pardoned, I am on my legs, Milos, and hence I am in VC, Milos.
All right.
Item 12.
May I please? Lord, in this case, challenging the order of the Honorable Single Judge on the ground that the Honorable Single Judge has not taken the legal position into account while dismissing the review petition, Your Lordship. My Lord, the conspectus of the matter is the petitioner challenged his transfer on the two grounds that the transfer.
Where is the order?
My Lord, 90 to 95, relevant pages 90, 193 to 95, 195. Your Lordship.
Page 95.
195. 193 to 95.
Just a minute. Which item is this?
I think
Who
it's
is it?
scanned and given us the wrong file or something.
Dr. Sanjeev Kumar Mohanty.
My Lord.
Scan the wrong file, isn't it? The WA, they've given us WPC.
No.
We'll pass it over.
Oh, how can we take them?
No, I mean, we will give them some protection.
Let it come tomorrow.
My Lord. Obliged.
But how can you challenge a review application, order passed in a review petition without challenging the original order?
My Lord, I have also challenged the original.
You will have to file, have you filed this thing, limitation application?
My Lord, no limitation.
Where?
It is within limitation. The review.
Review is within limitation. What about the original order?
Lord, I would file.
Wonderful. So this is the best way of getting the delay condoned. You file your review application. Belatedly, you get your review application rejected and then come with a plea that there is no delay.
My Lord, there is as such no delay, but I would file an appeal.
You don't know.
I'll file.
You don't know. Either you may say that the order passed in review application is only illegal. Whether that will serve any purpose or not, we'll see.
My Lord.
Item 13.
My lord, here, my lord, now, in the meantime, my lord, the minor mineral, that source has been transferred to the lord mining department. I have to make the mining department as a party, my lord.
Mining department or?
Mining-
Steel and mines, steel and mines.
Steel and mines department.
Minor minerals have, from 5/6/2023.
State of Odisha. All right, what is the point?
No, it is a PIL, my lord. The illegal extraction of, my lord, sands by the my lord, sand mafias causing a loss to the state exchequer.
That has not been leased out to anybody.
No.
No, your lordship,
That
from
last
the year
leased out in the year
2024.
2014. Thereafter, it has not been leased out, and but still, my lord, the mining is done there.
That
No,
is-
your lordship, I've got the
that is
PWC.
interest of the public. Public is mining without giving any fees.
I'll make the mining department as a party. Let it come in the next week so that in the meantime, I also.
Next week.
As requested on behalf of the petitioner, list this matter on 1 week so as to enable him to implement mining department
Steel and
Steel and
mines.
mine department.
Steel and
and
mines.
mines department as one of the opposite parties.
Item 14.
This matter relates to renewal of NOC in respect of the existing nursing college of the current academic year 2024-25 Miller. This matter was before lordship on last 27th Miller.
My lord, I have
On
got
that
instruction
occasion-
in this.
On that occasion, Miller, it was brought to my lord's judicial notice that one application for modification in your lordship, that comparative judgment along with Justice Raman Miller, that was supposed to be listed on the next day, 28. In fact, your lordship disposed of that modification application. Your lordship may kind of appreciate. My case is clearly covered, Miller. I have served the copy. By my case, every day of delay is a very tension for our institution in your lordship guideline, Miller. I'm just reading out. What is my grievance? My petty grievance is, Miller, there is a sheer deviance on the part of the authorities, DMFT and ONMRC, opposite 2 and 3, regarding the guidelines issued by the state itself in the year 2029, Miller. What your lordship modified on the last
2029 will come 5 years after.
Miller, no, my application is scheduled time, Miller. My application is within scheduled time. Annex 3 is there.
2029 is yet to come.
Mean 19.
2019.
2019, sorry.
9 or 19?
19, Miller.
Are you okay? Continue.
Miller, my annexure is there. That guideline is there. And my lord's order also referred to 2000.
So what do you want?
Miller, my grievance, specific grievance is there, Miller. Pursuant to their application for renewal, I made application in due time. That is Annex 3 series, Miller. As per their guideline, Miller, 2029. Sorry, 2019, Miller. I am everyone 29. Miller, as per their guidelines, Miller, I have quoted, I'm just reading out that person, Miller. It is there at page 46, Miller. I'm just reading out. Scrutinization of application, Miller. I'm just reading. On receipt of application, a scrutiny team shall examine the applications and the documents enclosed. When the documents are in order as per the requirement, an acknowledgement letter shall be issued by the council indicating that the institution shall be inspected for assessing feasibility for issue of NOC.
What do you want?
Miller, Miller, in spite of application, they are not responding, Miller.
All right. So you file an application, they are not doing anything.
Yes, Miller. It is
Just
their
a minute,
obligation.
just
Miller.
My lord, my instruction is, I am giving the instruction, my lord.
please.
Yes, my lord. That the institution named Nucleus Institution of Medical Science had applied for a renewal of NOC for BSc, BSc, ANM and GNM wide on the application number such and such, that on scrutinization of the online application, the deficiencies were sent to the institution wide letter number dated 24/2024 for compliance. That the verification on verification of the compliance documents, it is found that the fire safety certificate is not available. Fire safety certificate.
So
they have
did you
not put.
inform? Did you inform them?
Yes, madam. That is why the inspection was not conducted.
Have you
Did you
informed?
inform?
My lord, because they have given this information yesterday night, because I will get
When they gave this information, did they tell you that the information was given to them?
that has, because in the night they gave it.
No.
I will
This is written information.
by tomorrow I will get the information whether they have given the information or not.
All right.
Miller,
I will get it.
Extremely sorry, pardon, apologies.
So if they make fire safety arrangements,
Yes, ma'am.
then will you conduct the inspection?
No, they are noting is that so the compliance, so the inspection was not conducted as the fire certificate of, as for the notification of the government, because fire certificate is not available. That's why they have not gone for inspection.
You
Whether
understood?
they have intimated or not regarding the
No,
fire.
now the point is, if they do it, will you inspect?
Yes, they will inspect. The time, there is short time is
We
there.
will take up tomorrow.
Yes, my lord.
You tell us,
My lord,
whether you had furnished the fire certificate or not,
my lord.
and depending on the stand which they take, whether the inspection can be conducted. If you agree to install your fire safety.
Miller, after launch, I can also convey your lordship. After launch, Miller, because every day is crucial for me, Miller. After launch, may I permitted to contact my client?
One, you have to just seek one information.
Miller.
Whether you had furnished the fire safety certificate
Yes, Miller.
or not.
Miller.
If you had not given, then they're rightly not holding.
Miller. Oblige, after launch.
Yes, at 2 p.m.
I will also get them.
Please inquire.
Yes, my lord, I will inquire.
Item 15.
My lord, item 15, my lord. This is a petitioner is a candidate who appeared in the NEET UG examination.
All the applications have been, the Supreme Court has passed some order in this case.
My lord, in present case, it's something different. Why I am saying so.
Still, the Supreme Court has, in one of the orders, said that no court should pass any order in respect of this examination. Do you have any idea who is appearing for the Union of India? Do you have any idea? Do you have?
Mr. Kashyap,
Yes, my lord.
what
My
is the
lord,
order of the
yes,
Supreme Court?
yes, that is what my lord is saying. That is the correct position, my lord. It is yet to be decided by Honorable Supreme Court.
No, not that. Whether other courts should entertain these matters.
If my lord may kindly allow me one day, today itself, tomorrow, if my lord posts this matter, I will take instruction.
Please
What is the
examine.
correct?
Some order has been passed by the Supreme Court. Yes, tomorrow.
Item 16.
It's in item number 16. We got instruction now, after dismissal of the SLP, now we've decided to implement the order, so some time is required. So can be that. Now within 7 days it can be paid. It's an amount, some course is involved. So 7 days time we can comply.
As requested on behalf of the contemners, list this matter on 10 days.
Yeah.
So as to enable as well as requested by Mr. AGA, Mr. Franco and AGA on behalf of the contemners. List this matter on 10 days for him to seek instructions as regards to compliance of this court's order.
Item 17.
Violation of which has been alleged in the penal contempt application. Yes, annexure.
Plus, item 17 also I filed an interim application.
17.
Seeking for. Yes, here I paid for 3 months time, but also grant me 1 month time, it can do it.
What is the order?
IA is not here. IA is not here. You're saying you filed an IA?
Yes, Milos.
All right.
That IA is not.
Number you can give.
When did you file?
I filed it on Milos, 1st of July, Milos. Through e-filing, I filed it on 1st of July, Milos.
Hey, you filing they are not, unfortunately, not incorporated. What is the?
It is stated. List this matter on. By way of last indulgence, this contempt matter is adjourned to 4 weeks. Stop. This court will be compelled to initiate contempt proceeding against the contemners if in the meanwhile this court's order violation of which has been alleged in the present contempt application has not been complied with. He is not compliant.
For orders item 18,
Yes, but although this is listed for orders, my lord, if you also kindly remember, you also wanted the matter should come up for final disposal. But unfortunately, again, it has come for orders.
Why it has come for orders?
I have filed an application for vacation of stay, my lord. For that, the matter has been listed for orders. The last occasion, lordship passed an order on 26th, that the matter will be listed on 1st of July in the 2 p.m. Since
I
your
was not
lordship didn't hold the court on that day, that is subsequently listed in the orders.
No. The noting was that it will be taken up at 2 m for final hearing. Whether it is
Yes,
listed
ma'am.
for orders or.
Yes, ma'am. That order was in
We are
26th.
aware of.
That was on 26th, madam.
Yes. That
The
order
matter will be
is there.
listed on 1st July.
But is there any prohibition if the matter is taken up at 1:45?
Madam?
We can take up
Yes, ma'am.
right now.
Yes, ma'am.
Yes, my lord, you also hear the matter, my lord. That's right.
Yes. Though the matter has been listed under the heading for orders, along with the consent of the parties, we have heard the case on merits. Yes.
Wait, please, your lordship. I am the appellant for your lordship. Let's say post relates to vocational counselor. If you also kindly see annexure 1 at page 19.
Vocational counselor.
Sir,
Vocational counselor.
vocational counselor, my lord. That's the post.
Yeah.
But if you also kindly look at the advertisement that was issued by annexure 1.
Page. Yes.
It's a walk-in interview
Yes.
at page 19. So also annexure AY2 filed by the government in the counter merit. But there is one post of vocational counselor that is graduate with PG diploma in social science from Tata Institute of Social Science.
Where are reading?
If you are the fourth line, Malad, top.
Vocational counselor.
Vocational counselor. But a negotiation board will be held on 25/5/2001 at 9 a.m. at Spinal Injury Center, SCB Medical College. Bottom, Malad, that paragraph.
Yes.
And Hospital Cuttack. Interested candidates may attend with biodata with 2 recent passport size photos, certificates in support of age and qualification. Such contractual engagement, must be kindly marked. Such contractual engagement is only for 89 days and may be extended if necessary. Monthly remuneration is fixed by the project scheme. 1 month notice from either side can be served for termination of contract. Director reserves the right to accept and reject, cancel any or all the candidates without assigning any reason thereof. But on the basis of this advertisement, where the petitioner, the appellant for a lordship, was opposite party before the Honorable Single Judge, she applied and as well as application of the present respondent number 4 was the petitioner for the writ application. They also applied. If your lordship kindly see, 25/5/2001, the petitioner appeared before the board. That negotiation board. But she has the qualification graduate with PG diploma in social science from Tata Institute of Medical Science.
Social sciences.
Right. That certificate and all the documents of graduation, everything was filed. But that was, selection was held, annexure B/2. If your lordship kindly look at page 41.
Yes.
Proceeding of the negotiation board, the member of the negotiation board have approved the selection of the following candidates for the post mentioned against each candidate for contractual engagement for a period of 89 days from the date of their joining. Clause D.
Yes.
Vocational council, one post was there, my lord, contractual post. Sasmita Roy, present appellant for lordship. She was selected. I'm sorry, page 23. Extremely sorry, my lord. Page 23.
Yes.
This Premanjali Behra is respondent number 4. She got this certificate from Tata Institute of Social Science on the date September 2001. But the interview board held on 25/5/2001.
$25.
25/5/2001. This is a certificate from Tata Institute.
Yes.
Admittedly, she had not got the certificate of qualification by the time the selection was held by the negotiation board. Therefore, the petitioner had, prior to 98/99, she has qualified, got the same certificate, Marat. I'll bring it to your lordship notice. The selection board decided that petitioner is to be selected and shortlisted, and recommendation was made. She was appointed. She joined in the post. Next year, 2002, the same person who has been shortlisted, maybe there is another vacancy, I do not know. Petitioner, the present respondent of 4 was also appointed. Both continued from 2001, I continued, 2002, she continued. 2012, government created post. In the counter of the government, he has mentioned, I'll bring it to your lordship notice, the further affidavit that has been filed. When the permanent post was created, at that time they were all contractual, 89 days extended time to time. Then again the selection board was held to find out one post for the purpose of permanent employment in the spinal injury center. I also appeared and that was also considered. The selecting authority, they decided, in view of the seniority of the present petitioner and that she is continuing satisfactorily since all these years, which has been extended, she was selected to the person to be appointed in the post. After this, at the time of the advertisement was issued, apprehending that she may not get the appointment, the respondent of 4 had filed an original application. The tribunal held, at the time the tribunal was there, tribunal held that no, it is done as per law. So we are not going to interfere with that. As per the advertisement, it has to be done. So then thereafter the selection was made and the petitioner was selected. After he was selected, again another OA was filed. In this OA, counter was also filed with the government. Let's kindly have a look at the counter that has been filed with the government in the OA, which was transferred to High Court subsequently and decided as a writ application. So kindly turn to page. First, that advertisement is at Annexure 4, page 31.
Sorry, which page?
page 31, my lord, annexure 4. That letter dated 25/10/2012. Government of India, Odisha, Health and Family Welfare
Creation
Department.
of post.
Yes, sir. I am directed to say that government, after careful consideration of the requirement of regional spinal injury center Cuttack, have pleased to create the following 41 number of posts. One of the posts, serial number 5, vocational counselor, 1 post. Serial number 5, my lord.
No, that is fine, but isn't another letter missing? Because after creation of post, who is to be appointed, there must have been another letter asking for
Next, annexure
qualification.
5, my lord.
That is appointment,
Yes.
the selection.
Annexure 5 at page 33. Inviting reference to the above subject, I am directed to say that government, after careful consideration of the recommendation of the selection committee, so a selection committee was constituted. Selection committee for selection of eligible candidates for the newly created post of Regional Spine Injury Center, Cuttack, have been pleased to approve engagement in favor of the following candidates in the post mentioned against their names. Serial number 10, Sasmita Roy, the present petitioner. Vocational counselor. She was appointed. She continued thereafter. In that way that was filed, the counter is at page 35, annexure 6. Government's counter merit.
Yes.
It continued at page 36. Kindly see paragraph 1, sir. In reply to para 6.1 of the way, it is humbly submitted
No,
that
your page, referring to page.
page 36, madam.
Yes.
In reply to para 6.1 of the way, it is humbly submitted that the recommendation of the selection committee in absorption selection of the respondent number 4, that is the present petitioner, was based on the principle of seniority, observing all the provisions of rule of enforce. As such, the contention of the applicant that action of the respondent in absorbing respondent 4 to the post of vocational counsel is illegal and arbitrary is not correct. The next is, it is submitted that, on the basis of qualification required for the post of vocational counselor in terms of advertisement dated 21/5/2001, that is annexure 1, was graduate with PG diploma in social science from Tata Institute of Social Science. The respondent fulfilled the basic criteria required for the post. Besides required basic qualification of the post, he has also acquired practical experience. For this vocational counsel is to rehabilitation process. So the practical experience is also very vital in these matters. And she has experience in the field and was awarded Rajiv Gandhi Foundation Scholarship for undertaking the certificate course. Those are all filed. On the other hand, applicant, the petitioner, though a postgraduate, had not completed the PG Diploma Science from Tata Institute of Social Science at the time when the interview was conducted. As revealed from the record, she completed PG Diploma Social Science in the month of September, whereas the interview was conducted on May 2001. They have also brought the same thing to the lordship notice. The applicant was given appointment in March 2002 and pretty junior to respondent number 4. Respondent 4 joined a year after. So in page 37, if you lordship kindly see, it says further submitted that respondent number 4 was possessing all requisite qualification for the post of vocational counselor. She completed her graduation in 1993, successfully completed post-graduation diploma in social science from Tata Institute of Social Science 1999, acquired practical knowledge in the field. As such, she was selected and appointed through the recruitment process as vocational counselor by the selection committee in May 2001. First one. It is not out of place to mention that applicant was enlisted in the panel waiting list by the same body by selection committee during the course of selection process in May 2001. Subsequently, managed to get appointment March 2002 as a contractual staff. Had there been any discrimination or illegality in the selection process, the applicant would not have raised objection and challenged the same before the appropriate forum. Moreover, the applicant has challenged the engagement of student 4 after lapse of a decade. The 12 years after the writ application was filed, challenging the initial appointment to be bad. 12 years after, delay and latches also stares at the person. But in paragraph 4 of the counter at page 37, bottom it says that it is humbly submitted that number of employees of Regional Spinal Center, including the present applicant, is not were selected through recruitment process as prescribed by the government. They rendered service to the institution in their respective posts on contractual basis as no regular posts were created at that point of time. The next page, sir. Regular vacancies are now to be filled up from amongst the contractual employees so selected, rendering satisfactory service to the institution instead of going for a fresh advertisement. So that is the process of selection adopted, Marad. Accordingly, the staff rendered service on contractual basis were recommended, absorbed in the regular post so created on the principle of seniority following relevant recruitment rule, procedure, provision of ORV Act, etc. As such, there is no contravention of any of the provision of the law. But if you also kindly turn to the affidavit filed by the government.
No, I think paragraph 14 and 15.
Yeah, recently, madam.
No, paragraph 14 and 15 of the order of the single judge is relevant.
Yes.
They say that the qualification
is not there.
No, is not equivalent to the qualification it was required for the said post.
That was accepted, Malad. We filed all the documents. Both the same documents they also she also qualified, I also qualified, but she qualified subsequently.
No, the question is two aspects. One, according to you, in any case, respondent number 4 did not have the qualification on the date of interview. On the date of interview, and therefore, her or his inclusion in the panel itself was bad.
Right.
So even if respondent number 4 is he. Respondent number C. Even if she acquired qualification later,
right,
she could not have been appointed because after she acquired the qualification, there was no process of selection or advertisement.
Right.
This is one aspect of the matter.
Yes.
The other aspect of the matter is that you too did not have the requisite qualification in terms of the advertisement.
Right.
So then the entire selection process should be held to be bad. And then this practice of appointing for 89 days and thereafter absorbing.
No, it was continued 2012. 2012, the final selection was held.
Final selection was held from amongst you too.
Right.
So how
they are continuing since the last now about 24 years.
Continuing on 18 days, you may not be having the exact requirement, but permanent post. There's the difference.
Permanent post as per the selection procedure.
Yes.
They adopted the seniority from the contractual employee who has the experience. But this is, with due respect, my lord, this is a post not for any educational post like academic post. This is a post where experience matters. How you have trained, how you have experienced to handle rehabilitation of the patients.
Can we substitute the qualification which is mandated?
So they have undertaken qualification. My lord, with due respect, my lord, both have undertaken qualification before Tata Institute of Social Science, and that the project completion of the certificate was issued in their favor that they have completed the course. But that is construed to be the diploma course.
In our primary, we are of the view that entire selection process is vitiated.
But can I show you, Lordship?
First of all, you just show us.
Yes.
Your qualification was as per the advertisement.
Yes.
Come to this. The annexure 1.
Right, my lord.
Annexure 1 says
graduation
with PG diploma in social science.
Yes.
So PG diploma in social science. So how do you say that you had PG diploma in social science?
So that certificate itself speaks for it.
But
and that the certificate has been granted. If you are kind, I'll show one document. Mark,
But
to that effect.
the authority which granted the certificate, they say that it is not PG diploma.
That is what Annexure 8 that they are saying, Mark. If you are kindly see, I'll show one document, Mark. Annexure A/2.
Yes.
So I say Tata Institute of Social Science. So Sasmita Roy, University of Uttar Pradesh, so-and-so, certificate course in rehabilitation counseling of 1 semester in the successful
No.
completion of studies.
How do you, page 40? How do you how do you establish that she had PG diploma qualification?
So
Or-
this certificate that has been granted, that was they require this document in fact.
This is clear that you are granted certificate in rehabilitation counseling, not diploma.
Certificate in rehabilitation counseling, Nagas.
No, not PG diploma.
No, except what PG diploma is not there. To be honest, Madam, it's not there. But actually, this document relied upon this certificate that was granted relied by both the parties. And the reason for accepting this is kindly have a look at the affidavit now, the government's affidavit. They have explained why they have accepted. Kindly turn to the affidavit filed to the government.
No, but we'll still go by the advertisement.
Yes, that's true. But so kindly have a look at why reason. If you also kindly turn to the affidavit filed to the government, paragraph 4.
Annexure 7.
4. Madam.
Yes.
This affidavit was filed on 12th April 2024.
In this case.
Yes, madam.
Pursuant to order dated 10/4.
Yes.
So it starts at 107.
Because government, what the Honorable Court wanted that the rule
Yes, yes,
relating to engagement has to be produced.
Yes. Yes.
That says that the Regional Spinal Injury Center was established in 2001,
Paragraph 4.
same year. Madam. Registered a Society Registration Act funded by Government of India for a period of 5 years with the aim to provide rehabilitation measures to persons with disability, especially spinal injury persons, and the persons with orthopedic and neurological problems. Keeping in view of exigencies, the staff of RSIC were engaged through walk-in interview without following any relevant recruitment rule and procedure. They were being paid consolidated remuneration with annual escalation. Subsequently, the institution has been funded by the state government since State of Orissa since 2006. there was no regular post until creation of post by government on 25/10/2012. It is order by Sony Lordship. It says that the post of vocational counsel is neither available as a cadre post in any of the medical establishment of the state, nor in a specific rule has been framed in this regard. The post of vocational counsel originally was modeled in the line with Indian Spinal Century Center, New Delhi, who provided the technical know-how and training to staff, and also Central Institute, Swami Vivekananda National Institute of Rehabilitation, the training center to support it, who supported it. The qualification of the post was graduate with PG diploma in social science from Tata Institute of Social Science. This job was assessed and counsels spinal injury patients for any employment opportunity based on their skills, qualification, and viability, and motivating the patients to lead a near normal life. That was the purpose, in fact. Counsel of the caregivers of patient-like family members, peer groups, counseling the spinal injury patients about the rights and help them to get government assistance and other benefits from social organizations. Training patients with copies strategy to cope with in all situations. The vocational counsels are continuing in the institution as such. It is further submitted that, this is relevant, Malad. The petitioner in the instant case, Sasmita Roy, had obtained certificate course. They have taken note of certificate course in Rehabilitation Council from Institute of Tata Social Science, TIS, and also had obtained graduate degree in the year 1999, where Premanjali Behura was undergoing the same course at the time of advertisement walk-in interview. So this is the reason for which, because nobody was available. No candidate was available in the walk-in interview. These two persons or the petitioner herself only has this qualification, which is they feel or maybe felt at the relevant time that good enough to appoint the post on contractual basis to carry on with the work which is required to be done immediately. Because that was opened in 2001. It was first time they're trying to introduce such a thing.
The entire selection process will have to be advertise the post and then may give you, but your appointment is also equally illegal.
No, I'll satisfy your lordships.
Mr. whether you were qualified on the date of advertisement or not.
In the advertisement in 2001, none of the parties was qualified.
Therefore,
Subsequently, before the regular advertisement, I have completed the course.
Please, Mr. Counsel, when you were engaged in 2001, you did not have.
I have engaged in 2002, my lord.
You were engaged in 2002 without any advertisement.
In that advertisement, my list was in the panel.
How your name was there in the panel?
Well, because there is
because someone had played fraud.
No, my lord. Because at that time no one qualified the.
So how did you walk in for interview?
At the time of interview,
you did not have the qualification.
On the basis of what document had you applied? Because they needed some certificate. She had some certificate. What did you have?
I have continuing. I have filed that certificate subsequently on July. Because
Mr. Counsel, the entire process stands vitiated because that is based on walk-in interview. Walk-in interview in the advertisement qualification was mentioned. None of you had the qualification prescribed. So therefore, the entire and the selection has been done from amongst two of you. So that post could have been advertised after the creation of post. But what right did you have?
My respectful submission, at the time of advertisement made in 2001.
We have understood.
And he has not completed the same. She has not completed the segment. I have also
that. You are not understanding what we are saying.
Since the walk-in interview, we are both are engaged on contractual basis.
No, that is all right.
Sir, when did you acquire your qualification?
2001.
You acquired your diploma?
Yes, in diploma. No, not in diploma. This is diploma certificate I have acquired in 2002.
All right, just a minute.
In 2001.
Just a minute. After 2002, whether there was any advertisement?
No.
Then
But I 2001, I have also acquired the qualification of
understood, Mr. Counsel.
First year course.
We have
This is the
understood.
first semester course.
We have understood.
Neither of you were qualified. So we only want to find out what is the procedure they adopted for engaging.
Sir,
him or
complete fraud on the
us.
constitution.
I am
What?
I am submitting a just written note, madam. Just a that's it. I am submitting.
Give.
Yes.
Give whatever.
I'll
Both the appointments we are going to hold illegal, entire process illegal.
So the selection was in the selection only these two persons were considered. There was no notice or no advertisement asking for other applications.
What kind of the
Madam,
colleges? The
important,
manner in which the colleges are running.
well, the relevant is that
We have understood what is relevant, Mr.
Sure.
Counsel. The most relevant is fairness in the process of recruitment and selection.
Yes, madam.
That's all.
Yes, madam. Yes, madam.
Well,
One thing I would like to bring your notice, the petitioner is continuing the present.
none of you will continue.
No, there is no mechanism. No, till they select, actually, if your lordship indicate that they should select as per the procedure.
They may do. They may give you preference. We don't know. But they will have to adopt some fair process.
Yes, but
That's
till
completely.
this selection process is done, with the humble submission is that, till it is done, let me continue because I am continuing
Let us
since last
see. We will deliver judgment soon.
May
24.
We may deliver judgment tomorrow.
may I draw your honor's attention one line. My lord, I have, though at the time of walk-in interview, I was not qualified as per the advertisement that PG there. But subsequent 2002, I have acquired that.
Mr. We are putting another question.
Yes, madam.
We are putting another question. There were 20,000
Yes.
candidates in Odisha who were equally qualified as you.
Yes.
All the candidates pursuing their courses in TES, all of them had the same qualification which you had. But because they saw in the advertisement that diploma is the minimum qualification, they did not apply.
Yes.
You applied.
I have applied. They also
Oh,
applied.
yes, both.
Well, my question, madam.
Yes.
Don't
When
be
the-
excited, Mr.
but-
Mahapatra.
No, madam.
Neither of you were qualified.
No, madam.
That there is no doubt.
My respectful submission,
On the
madam.
date of
When the
interview.
regular advertisement was made in 2012, it is an vacant interview.
Listen.
But the regular advertisement, when I have drawn your lordship's only regular advertisement, what is the grounds there?
that
is
we are asking, Mr.
That is
Mahapatra.
the important main para 3. The above
We
post has
have to deliver the judgment. So if you don't answer our questions, talking continuously is not going to help you. We have a doubt. You tell us. At 2012, what was the criteria for appointment?
That was the criteria.
What was the criteria?
Which was adapted in 2001.
Where is it?
That is not specified there, but that language is there. The above posts are to be
Where?
filled up in a transparent manner,
Where?
following relevant recruitment rules, procedures, and the where.
So what
So
is
this
the
is transparency.
That transparency,
We shall pass restriction.
Promotion is
Mr.
not the transparency, and promotion
shall pass-
has to be done from the.
You please, Mr. Counsel. So state in this case.
So that's that case. Your matter, Mr. Mishra, that one only.
Which you argued.
The one which both of you are last case before recess.
So let it come tomorrow. Tomorrow you will hear.
We want to know what procedure you have followed in selection.
We will hear you on this point only. As to what procedure did you adopt after the posts were created. That's all. Or a post was created. Yes.
Item 14.
As per your lordship, kind Puri in the fast track Miller, I feel it my obligation Miller to intimate your lordship with regard to two information. regarding the status of fire safety certificate of the institution and whether the rejection order after compliance, it was communicated to the institution officially or not. That was their query, Miller. Miller, as per my instruction, Miller, that is the status, Miller. I was by the institution last occasion.
Don't show us any
Miller.
document, whether fire safety certificate was
Miller.
given by you or
Miller, the
not.
undertaking was there, deposit is also there, Miller. And last occasion, based upon an inspection, joint inspection, I was allowed to.
There is no question of last inspection.
Miller.
We are required to make your application for grant of NOC.
Miller.
In that application or with that application, you are required to enclose your fire safety certificate also.
Miller.
Whether that was there or not.
Miller, that was not there.
Then
My
we will see.
my undertaking was there and deposit also there, Miller.
Deposit will not ensure fire safety.
Miller, the institution.
All right, we will see.
Miller.
We just wanted to have this.
Miller.
Hearing. Huh? When is the date?
He said he will get instruction.
Yes, you seek instructions.
Lord, I got the instruction.
Huh.
He has not applied for with certificate.
Huh.
And up to 30th of June, we were accepting all the latest. From 1st of this month, we have started writing letters to everyone regarding the deficiencies and all that. And for that institution, today they are issuing the letter also.
Yes, Your Lordship, with that obligation, Your Lordship,
We are disposing it off.
Miller, as per whatever my learned senior friend has submitted, Miller, they have, as per his instruction, the department is supposed to issue the deficiency letter to the institution on today, Miller. Miller, deficiency, then whether as per the undertaking, if
Then he will let him submit
Miller.
the deficiency to the court and the court will hand over to you.
Miller.
Right. Are you?
The deficiency is saying letter will be issued to you. Probably some time will be granted. So you have to comply with that.
Yes, Miller.
So why should it be kept pending?
Yes.
Yes.
Okay. The present writ application has been filed on behalf of the petitioner seeking direction to the DMET to conduct inspection of the institute, namely so and so, for the purpose of grant of NOC for academic session 2024-25 in respect of BSc Nursing, BSc A&M and GNM nursing courses. Stop. Next, learned counsel appearing on behalf of the petitioner has argued that every day delay on the part of DMET in causing inspection of the institute may adversely affect the fate of grant of NOC in the light of this court's decision in case of GK Nursing Institute.
Back case.
That bad case. I have provided the judgment.
GK
Nursing Institute.
Order, that is the.
Miller.
in case of दोनों order लिया Stop. Learned counsel representing the DMET has informed this court that upon scrutiny of the petitioner's application, certain deficiency has been found, particularly regarding non-submission of fire safety certificate. Full stop. A communication is being made to the petitioner in this regard. Full stop. Once the petitioner meets the deficiency, comma, the DMET will consider causing inspection of the said institute. Full stop. Next, in such view of the matter, in view of the stand taken on behalf of the DMET, learned counsel for the petitioner admits that fire safety certificate was not enclosed with the application for grant of NOC. Stop. Next, in such view of the matter, this application is disposed of with an observation that let the petitioner's application for grant of NOC be considered in accordance with law.
A
Yes.
pardon, my lord, grant of renewal of NOC.
A grant of
Okay.
renewal of NOC.
All right.
Renewal book.
Item number 7.
Yes.
So the in-campus medical stores, but the government was supposed to come up with, because they say that they will file a counter or instruction they will obtain.
No, this is WA, right?
My lord, will hear this, take up these matters, my lord. I don't know anything about any instructions to be given by. it
Mr.
is a-
Counsel, should we close our High Court?
No, no. No, my lord.
Your government has not appointed an Advocate General. That is a constitutional mandate. And please see it's Article 227.
Yes, sir, my lord, I have.
Please read Article 227. Oh, sorry, 177. There is a vacuum. It's a constitutional vacuum, Mr.
Yes, ma'am.
Should we record?
No, my lord.
Should we record it in our order?
No, my lord, I will convey your lordship's concern. My lord.
But if I am not wrong, in fact, in those days, in fact, the first appointment after the chief minister takes charge.
Everywhere that was.
That is.
And in fact, this matter was last time led by the then Advocate General. In this matter was very sensitive matters as all.
No, apart from this matter, it is the practice which is followed. And number of matters.
Your state has also filed one appeal, my writ appeal, challenging another.
ये कॉल कैसे
163. The governor of each state shall appoint, which is 163.
Let us see.
I will convey, my lord.
May not.
Last week also, we had expressed our concern last week. So something.
So you don't So we will have to record at least this, that you don't know anything about the fact.
Which fact?
Then this case,
Yes, yes, I know.
this case you will argue.
Yes, yes.
All right. Yes, let us see. Yes. Yes, yes.
Last occasion, you must remember, in the course of hearing, you must have wanted the advocate, the then advocate general. Whether, the only thing is whether they can be allowed to continue their sub in the last 2 decades, they're continuing. Whether in addition to the subs, they have now decided that the free of cost medicine. And this is a medicine sub, day and night, 24 hours medicine sub inside the campus.
No,
We also wanted to know.
See,
the
there
advocate
is
said,
there is,
Advocate said that I'll take instruction whether they can accommodate or they can change the. That is what, in fact, what was the discussion, that is why the metro judge.
no, but there is a finding recorded by the learned single judge, which you are challenging.
Yes,
And
yes.
because of some interim order granted, you are still continuing.
Actually, the license and everything is continuing. Because they terminated, actually, they wanted to terminate it, therefore the interim order was there.
The policy per se did not say that we cannot continue. Only it was for opening of the free shops. So
that
we have
was never
also
objected.
continued. We continued for last 10 years along with the side of those free shops.
Sir, on the basis of interim order,
On the basis of interim order.
Yeah.
So the finding of the court that there is a policy decision that itself is factually wrong. That's all. In fact, that's how.
Nobody challenges the policy decision.
Nobody challenges the policy. Policy does not say about a discontinuation. That's where the single judge decision is factually wrong. And to that extent, I think the instruction, which was an understanding,
advocate general the other day-
there at that time. So he may not be aware, but it was an understanding. So it comes after vacation and in fact, one of the single bench also. has
is there
given
anything in the order? No.
No.
It is understanding.
There is a single bench order also.
in our favor.
There are
Exactly
two
says this point. This is Sinha's judgment.
One of the.
And that was challenged for the Supreme Court.
They have challenged that.
Ah.
That's also still-
Read
So that has not been tagged with.
That
the
has
case.
not.
That has not been tagged.
State has filed.
So that is what Mr.
Yes. was there.
Ordinate bench actually held in
There are
favor
two
of.
divergent view of two single bench of this honorable court, my lord.
Judge, the impugned order, it only says let's keep it on hold for some time. It does not say that they will not be renewed or they will be terminated. Just keep it on hold. So the whole thing has actually been upside down. So therefore, I think that other matter is also called, I think, a greater clarity in.
Because whatever we are submitting, my lords, has been upheld by Justice Sinha. Whatever we are submitting.
Single judge.
Single judge,
now-
now the honorable single judge has upheld our contentions.
So that is a single matter. Here they have.
Yeah, that has been challenged here,
Same
my
thing,
lord.
principle of law. has been
That
said.
the state has
By the
challenged.
state.
Where is that one?
And
That has
that,
not come, that has not come.
That has not been tagged.
that has not been tagged before.
The other
That
single.
order has been annexed in any of the.
File counter.
That is another.
I have annexed my writ petition, my lord.
Oh, you have annexed it.
Which
I have annexed item sub-item number 15, my lord. Writ petition
Oh,
1038.
So page 144, I think, in that.
We have quoted the entire order in extenso in our writ application.
Mr. Swami, 1038, which page?
1038, page, my lords, 99. Judgment.
First matter, page 153.
Yes.
No, see.
You said you have annexed that in the writ petition, no? In the writ appeal or in writ petition?
Writ appeal, my lord. Writ appeal 1038, 24. Page 99.
This order was passed prior to this impugned order, my lord.
Yes, into 20.
And that has also,
2022.
this was passed in 2022.
That is challenged by them. Relevant person is 104 minutes, so it is held arbitrary.
Relevant portion you highlighted, so we are unable to see if it has been scanned, everything is black.
So paragraph 10 of that judgment is very. Paragraph 10.
Paragraph 10, he has highlighted and made it black.
Upon function.
You'll also see look
Oh,
at
oh.
the lead pattern.
Yes. State has not implemented impugned policy till date.
That sentence starts from that.
Paragraph 10.
Para 10.
Judgment. We have the copies of.
And there is no disclosure to show otherwise.
Yes.
Oh, this was a simple case that your renewal was not being allowed.
Yes.
Yes.
That is why it was decided or done thing. That's it.
All the cases are
All the
same. now.
same manner.
Same. now.
27 February. 15 letter is on the check.
No,
all
the
the cases.
reasoning here is that they have not taken any steps to implement the policy, so why should they not renew? And there is nothing on record to show
The
that.
observation is that even if implemented, doesn't is a threat to the.
As on date, my lords, even the
There
hospital
is
depend
also
on us, my
nothing on
lords.
record
Most
to
of the
show
medicines are
they
not
want to
available in these free shop medicines, my lords. They depend on us. I've got, my lords, I'll file it, I'll show your lordships. All the requisitions
Does
raised by
appear
the
to be
hospitals to come to us.
refreshed.
They are not, they don't possess these medicines.
Petition.
And there is no question of, my lords, our operation, my lords, throwing out these shops which offer free medicine, my lords. We can both coexist.
First prayer was you were challenging the policy.
We are
No,
telling
Just wait. Because there were two prayers.
No one is.
You withdrew one prayer. Because this has no application to the case since the petitioner has withdrawn his first prayer. What was your first prayer?
challenging the executive instructions dated 27/2/15 manner.
That is the policy manner.
That's not policy, that is the executive instructions manner. That is wrongly quoted as policy manner. That cannot be a policy.
Okay, so there is no.
Because
policy.
our policy,
So there is no policy.
27/2/15 is not a policy manner. That is executive
There is no
instruction.
policy.
But there are policies,
Don't shout it.
other policies. There are other policies under which our license has been, our lease has been given, my lord. 2012 policy is there.
So how this Krishnan Kankant decision is applicable?
Okay.
Krishnan Kankant decision which has been relied on in this case.
These were referred by the government.
Government, that was not relied upon by the senators. Understanding.
Paragraph 10, he gives his findings. Paragraph 10, everything in state has not implemented improved policy. There is no fetter on state to
Alright.
establish.
So what is the policy?
Order date, they're referring to order dated 27/2/2015.
20?
7 to
February.
2015.
14.
14.
15. No, 15.
So there's policy contained in this.
Yes, that was just an executive instruction that you don't renew it for the time being.
So they have not implemented.
That's what was observation.
Thereafter,
But then as and when people started coming to renew, they started implementing it against individuals and they started.
no, but there is no decision of the government that government.
No,
shall not
what is the basis of this finding that the state has not implemented the policy?
That means there is a policy. Yes, Mr. Patnaik.
That must be Niramaya policy. Most probably that Niramaya.
That is Niramaya
Yes, yes,
policy.
Mr. Patnaik.
That is a my lord Niramaya policy where we have made medicine free to the
Huh?
medicine free to the inmates of the patients of the hospitals. That is my lord.
So that means the shop will give free medicine.
Those not those shops. There will be Niramaya shops which will distribute free medicines. That is the single judge in the present writ appeals. That is under challenge. That is what is.
And
that's
this
not
petitioner,
Yes,
this
yes.
petitioner was continuing in license under interim order.
Yes, yes.
You'll also say two things. One, there was an overall policy of the government to have certain outlets in various hospitals and CHCs that will distribute free medications.
Yes.
That is this Niram.
Yes, that's
Yes.
not under.
That is my lord
No,
para
that's not
para
under-
9 para just wait
That's
para
not
9
under-
of the impugned order, my lord, of the honorable single judge, my lord.
That's why the single judge has committed the
No,
fault.
let us understand. Why are you not renewing?
Because we are decided that where there will be free medicines inside the campus, we will not have any other medicine shops. That is
Where
the
is that policy?
Where is that decision? He says so. Where is it?
No such policy.
Please,
No, I'm sorry.
so you cannot put questions.
Ah, I'm sorry.
my lord my lord, that is my lord. They have impugned one order.
Where is it?
My lord, I'm just reading the page 36 of the brief.
Which brief? This is on the first case.
WA number 96024, my lord.
Page 36.
Yes, my lord.
That is the single judge judgment.
Yes, my lord. There I'm.
That must be a reference. So
The
where is
scheme
that
was
policy?
implemented in May 2015, my lord.
No, do you have any policy that you will not renew the licenses of the existing medicine shops?
No.
Is there any policy?
Yes, my lord. That is
Page.
that is
You assist him. Since he was not there last year, you assist him.
You can see that page 87 in WA number 896 of 2024.
896.
896, where is that?
963 of 2024.
We are looking for that WA, wait.
That's the resolution 17 2030.
963.
963. 963.
963.
Ma'am. That was the resolution. Which the government wanted to implement it.
Annexure two.
That is not been mentioned.
It is not a part of the record, my lord.
Copies of policies, so annexure
That
two.
I am reading from the deed of appeal.
Tell the page, tell the page.
And that page 87.
Okay. Annexure two, serious part of annexure two, not illegal. Petition. भगवान ने वो चीज झाड़ा होता है.
Lordship got it?
Yes. 17/2013.
Yes, my lord. That the government wanted to implement it. Lordship can find it from page 92 and 25/4/2015.
On the basis of this policy, they were allowed to open these shops.
Time to time you come up with policy.
Different things.
Yes.
But this is not what they've relied before a single thing.
This they were allowed. Thereafter,
Thereafter, my lord,
This was challenged in different petitions.
No, thereafter the
No,
letter
no.
dated 27/2/2015.
Just look at page 92 of the lead.
Page
That was
92 of the first brief, if your lordship looks at.
In fact, our suggestion would be that please prepare a plan.
Yes.
How you will make your submissions.
My lord, my lord.
You will lead the case. And then thereafter, one senior counsel should address the court.
Well, convenient
On the merit.
compilation will help. my lord.
And thereafter, if something is required to be added to those submissions, we'll see, but there must be, hearing must be in a planned manner, not like this that. Is this matter under the same heading on? Next week, 2 p.m.
Plus next week, I won't say that. Week after next.
Week after, but there is interim order continuing.
so many seniors are there.
Week after next. my lord. My clients also, my lords, they have their anxiety that day.
So that
Week
is
after
your
next.
client is to stay. At a co-item.
Exactly.
7.
Any date. 15.
Date you will get.
Item number 10 and 11.
Yes.
Item number 10 and 11.
Similar matter. Here it has come for the first time, Lordship. Interim order. Item 10 and
28.
28.
28. Same case.
Week after next. And week after next.
But I
We'll get the date. Date, Pratap.
Yes, deeply.
Item 10 and 11. Interim order.
Obliged.
12th to night, date.
14th.
Compilation to file होगा ना 14th. Car festival is there next week. You know, so fix any day thereafter.
Yes, yes, we're fixing. Okay, because of day of the month.
We commencing 22nd is the available.
We come in the August.
Obliged. Interim orders may
No,
continue.
interim orders continue.
Obliged.
But I'm very, I'm not happy.
No,
The manner in which the case, these matters have been adjourned and the cases have been conducted. Want a date? We have given a date. 1 week after, you have problem. Thereafter, someone else will be having problem. Let it remain pending. You are happy because you have interim orders.
No, my lord.
no, but
But you are,
Week after next.
No.
month, I'll be there.
sorry. It isn't on the way.
Item number 10, 11 and 28. Next. No interim order matters in these cases, so interim order may pass. Grateful. Item number 19.
That's you serve copy.
Item 19.
Yes, sir. My input order is at page 16.
Yes.
The only question for consideration, my lord, whether on the date of death, the rule governing the field, or on the date of constitution, the rule governing the field, which will be applicable. But this is the direction, but this was considered in 2020. By that time, the rule was amended. So they have considered in 2020 rule and they have rejected. Honorable single judge had directed to consider his case in accordance with the old rule. This matter has already been, similar matters has already been set at rest by this honorable court in the case of State of Odisha versus Bindusagar Samantha. And relying that judgment, my lord, your lordship also have given 2 copies that relying that judgment also your lordship has already passed.
No, but is there any decision contrary to the view which has been taken in this case?
In
Sagar?
this
No.
case, my lord, no, my lord, there is no contrary, sir. This judgment of this honorable court is challenged before the honorable apex court. That is pending. That is the admitted fact. That has not been set at rest before the honorable apex court.
No, but we are under the impression that there is some decision of a division bench which runs contrary to the decision in case of Bindusagar.
No, my
But
lord.
he was informing that before this decision, there was a decision which was not shown. I mean, what was not noticed.
Relying on Santosh. or
Yes, my
something.
lord. Yes, I'm submitting. That one Malayananda city case, that in that case, State of Odisha has come with a writ appeal in that State of Odisha versus Malayananda city. That the view of this honorable court was that since on the date of consideration, the rule governing the field, that will govern. That was carried to Honorable Apex Court. Honorable Apex Court in that Malayananda city case felt that as in a particular facts and circumstances of the case, without relying the 2020 rule, that is a bar under 2020 rule, the pending cases will govern under 2020 rule. But in that Malayananda city case, this judgment of this honorable court was set aside, keeping in the view that particular facts and circumstances of the case. Subsequently, that I have given that judgment that Bindusagar Samantha, in Bindusagar Samantha, Malayananda city case and other decisions were taken into account. The honorable court there, your lordship can find it that held that Malayananda city has taken into account the rule 2020 rule, and that cannot be taken into account even if there is a provision under rule sub rule 9 of rule 6. All even if cases are pending, that will govern under old rule.
Cases?
The pending cases.
Pending,
Your lordship will, I'll clarify that if your lordships will see that.
Cases pending when the new rule came into
Yes,
existence.
that is the provision your
They will
lordship
be
can find it that I have annexed that rule, my lord. That was the barrier for which.
No, Mr. Kuntia, what we were saying was before this Bindusagar decision, there is
Malayananda city case was there.
another one was there before this by a division bench of this court.
This is division bench of Malayananda city.
After Malayananda city.
After Malayananda.
Of I think Chief Justice Muralidhar.
That is the Malayalam.
Consider.
My lord, three judgments in this regard. First judgment is Malayananda Sethi case. Then second case is Suchitra Bala case. Perhaps Suchitra Bala case, your lordship perhaps is a member to that with Justice Talapatra, my lord.
No, I think.
Thereafter that Bindu Sagar case.
Okay. So Suchitra was in which line?
That in that Bindu Sagar line. All these judgments have been taken care of in that Bindu Sagar case.
Can I sum? Yes, my lord, this regarding the old rule, the new rule coming into existence, my lord, if my lord will go through the impugned order. No, this, but see, is it not your case that your case should also be governed by Bindu Sagar? My lord, sorry, my lord.
Your case is not governed by the decision rendered in case of Bindu Sagar.
Bindu Sagar, my lord, is it's with regard that 2020 rules, and I am definitely fall under the 1990 rules. But
So this is what he is saying.
yes, my lord. So my lord,
There is no conflict.
no, my lord.
So we are condoning the delay and we have disposing of the petitions.
Yes, this order,
Right.
last week also we passed out.
But it is my duty to bring it to my lord's notice. It is my duty to bring it, my lord. Here, the impugned order, single judge order, was not considered on the rules, my lord. It was considered on the factum that whether I was a family member or not, whether the medical certificate was there or not of my mother. So it was under that consideration, my lord, single judge has passed the order, my lord.
Oh, this is different then.
That is my. They had taken a plea in their counter, my lord, with regard to the rules.
Yes.
But
So who are you? You are
I am the son of the
son of the employee.
deceased, my lord, son of the who has died in the harness, my lord.
Yes.
Thereafter, I filed my application, my lord.
When did he die?
He died in 2012, my lord.
And
To
when did you
13/3/2012, I applied, my lord, on 22nd/8/2012, my lord.
Yes.
Thereafter, on 16/10/2014, my lord, fitness certificate of mother of the applicant was sought, my lord.
Yes.
Then on 8/2/2015, mother of the applicant was asked to appear before the medical board
by CMD, Mayurbhanj. On 36/2015, my lord, the applicant was asked to appeal. Thereafter, my lord, I'll show it from the read, my lord. My lord, may I see annex of
Next, sir.
4. 21/6/2013 letter, my lord. Appointment of Sri B.K. Raut and Sri Junesh Kumar Sethi, my lord. With reference to your letter number 2193 dated 9/5/2013 on the above mentioned subject, I am directed to say that on verification of your proposal for appointment of Sri B.K. Raut and Sri Junesh Kumar Sethi on RS scheme, following the shortcomings are noticed. Proposed place of posting of B.K. Raut and Sri Junesh Kumar Sethi, non-engagement certificate of all legal heirs of late K.C. Raut, family maintenance certificate of Sri Junesh Kumar Sethi in shape of a court
So they
affidavit.
will reconsider your every aspect.
Your Lordship, see para 10, my learned friend saying that I don't have, Your Lordship, for a moment, para 10 of that order. Your Lordship, see.
Petition claim has been illegally rejected and accordingly this court is pleased to cause this said rejection.
And
While quashing the same, the court directs OP number 1 to
This, sir,
take
in accordance
take
with
appropriate
time of the,
step
yes, ma'am.
and take fresh decision in accordance with
ma'am.
rule prevalent in the time of them.
Yes, ma'am. This is
So
done.
this is what,
Yes, my lord.
and
This
we
is,
cannot direct appointment.
no, my lord. It should be considered, my lord, that much.
That I am relying.
No, I thought, my lord, because the
That they
issues,
will examine.
With these,
Yes.
it is true. That order may
rejection
pass.
was different on the, rejection of my candidature was on a different
So
ground.
they will consider.
My very.
Yeah.
Item number 20.
In item 20, Lordship, I have filed an IA that is 246. Sorry, 746 of 2024. Why I have filed that I have, Your Lordship, I want to draw my Lord's notice. Your Lordship, see the was title
1775.
264 of 2024.
264.
My lord, IA.
264 is not there. 264.
My lord.
There is no such a.
746.
264.
Sorry, my lord, 740. Sorry, my lord, 746. 746.
Modification of order dated
I have filed my lord. Your Lordship,
WA number?
My lord, 85.
853. That IA was mentioning in
No, but where is that IA?
746 flag D.
Like D. Yes. So what do you want?
before going to that, I want to draw my lord's notice, my lord. Page 101 of the writ appeal.
Oh. Regarding service of notice.
Yes, ma'am. That is the problem. Your Lordship, I see 101. Nothing is given because in this writ appeal, I cannot also change that. And notice cannot be issued. On Your Lordship, I see my Lord's order that thereafter on this, Your Lordship has passed order on 13/3/2024.
Mistake.
And I wanted to serve a copy on the counsel who was appearing, but he doesn't.
He declined. Is there any interim order passed in this case?
Yes, Your Lordship has passed. If Your Lordship will give me another opportunity so that I
Whether any interim order is there in this
Yeah,
case?
yes, on 13/3/2024, your lordship has
Contempt application. Operation of
protect-
the order, impugn order, the state.
I'll pursue him to take notice of, because 1200 persons are there. So no address is given and I cannot change in my writ appeal their address.
Oh, where they give it care of the
Yes,
council.
that is the problem.
Ask him to be here
Yes, I tell us fix it to next week.
tomorrow. Ask him to be here.
Tomorrow, no, next week.
The state of Odisha has put to challenge in the present intra-court appeal an order passed from the post title of WP number WP
OAC, ma'am.
WP bracketed OSC number. So it appears that the respective addresses of the respondents / petitioners were not mentioned, and instead, whose address?
Council's name, please.
At that time, madam, Justice Biswajit Mahathi was appearing. So at present, my Sadashiv Patra is appearing that contempt petition. So I'll serve copy on him and I'll request him to be present before my lords.
Bhakta Ranjan Mohan.
Some of the respondents, one Basudev Barik has appeared, for some.
Admit
And then you've also granted liberty for vacation. That will come soon.
admit.
Yes, Mr. Sadashiv Patra, I'll request him.
Ask him to come here tomorrow.
Yes, ma'am, I'll request.
Tomorrow. This matter tomorrow. We request Mr.
Sadashiv Patra.
Sadashiv
Patra, ma'am.
Patra to be present. The Patra Land Council who represents the contempt petitioners in contempt case number.
Contempt. Just giving that.
Five 5819 of 2023.
I'm giving that.
That is there in your prayer. Prayer in the IA.
Yes, ma'am.
If you want to serve copy on counsel who's appearing in contempt. 5819 of 2023.
See the order dated. Number two.
Kuntia, in your IA prayer
Yes.
of IA 746.
Could you get the contempt?
Yes, I'm
We are pursuing the contempt matters on behalf of the petitioners, on behalf of the respondents to be present, having regard to the facts noted in the order dated 13/3/2024, passed in this case.
Item 21.
Lordship, here have two interim applications, Lordship.
You are for the petitioner.
Lordship, I'm for the petition.
Yes, what is this about?
Lordship, 8210, Lordship, that is for amendment of the rate application.
No, what is this rate application about?
Lordship, here, Lordship, after completion of the auction procedure, they have enhanced the royalty, which is never permissible in the IF law. That's a Lordship in this matter. A Lordship interfered in the matter and has granted state Lordship in all the cases, Lordship. During operation of state Lordship, now they have stopped mining and now they have issued another letter. No, again you pay the further royalty. So my humble submission, Lordship, kindly take up to 8211 rate application, 8211. Here, Lordship, I have given the document also.
Now, where is the stay order?
Lordship, I have quoted in my miscase, Lordship, the order dated. Lordship, 31/8/2023.
Yes.
Lordship, if Lordship will permit, then I will see the entire order, Lordship, or the operative part, Lordship. Operative part at page 4, Lordship, that is. Without prejudice to the rights of the contents of the parties, as an interim measure, it is directed that the subject to deposit of 30% of demand amount by the petitioner by 10/10/23, the demand so raised under Annex 7 shall be remain stayed till 13/10/23. Then we will have quoted the subsequent orders. It has been extending from time to time.
So you deposited 30% of the
Lordship,
amount.
I have deposited and they allowed me, Lordship, to issue transit permit.
Then
Now, Lordship, they have stopped, Lordship. Now they have stopped.
that they could do.
During pendency of the writ application and operation of interim order, Lordship.
Interim order, you please come to the order of this court, 31/10/2023.
Lordship.
He wants to confine his prayer for quashing the demand notice.
Lordship.
That's all. So you cannot raise any other point in this case.
But Lordship, my Lordship, para 3, Lordship, Honorable.
Paragraph 4 is very clear.
Lordship.
So interim order was granted because you confined your prayer to that only.
But at the relevant time, Lordship,
There is no question of relevant time.
Lordship.
This writ petition is confined to this only.
But Lordship, so Lordship, that notice pertinent to the entire reality, Lordship.
See,
pertinent
that
to-
was relating to 24/8/2023, not beyond.
Lordship, that's true, Lordship. I'm on that only, Lordship.
All right.
I'm
So
that
we
on
will
that,
find-
Lordship.
We will consider that only.
Lordship, Annex 4, Lordship, kindly see for a moment date to date application.
So on what ground are you challenging this order? Demand notice dated 24/8/2023.
Demand notice, Lordship, auction was conducted, Lordship, with proper notification as per the Orissa Concession Minor Rules 2016. We participated. We became, Lordship, become the successful bidder. And as per the terms of the agreement, we executed the agreement and we deposited the Lordship amount as per the advertisement. After deposit of the entire realty, Lordship, as per the terms of advertisement and agreement, by relying of a decision of the committee considered by the state government, now they are enhancing the royalty. They are saying, no, this amount you have to give, Lordship.
So where is that demand notice?
Lordship, that is, Lordship, kindly come to Annex 7 here, Lordship. That is page 84.
Yes.
Lordship, I'm reading, Lordship. This is intimate that at the time of auction of Brahmani River and Marjidapur on 11/2/2022, the rate quoted by you of rupees 35 plus 49, for which you had been adjudged as the highest bidder. However, on scrutiny of the case records, it has come to notice of this office that additional charge has been substantially enhanced by the district level committee to rupees 35 plus 234 at the time of grant of environment clearance based on the instructions received from the office additional chief secretary. They have given the reference dated 7/4/2022. Hence, it is directed to deposit the following amount in Tahsil office within 7 days, positively from the date of receipt of this letter, applied to city and CTO before the competent authority to execute list deed of the operation of the said source, Lordship. So, Lordship, they have come up with this proposal after completion of the entire action procedure, Lordship. That was never a condition of the contract. And they have also given, Lordship, the finding observation that what are the price, Lordship. And after completion of the action procedure, relying upon a subsequent development, they have come up with this price,
Where is the
Lordship.
tender notice?
Lordship, that is at Lordship. Lordship, here I am not annexed to the tenderical notice, but I am the environmental clearance. State Lordship.
Where is the auction notice?
In this case, Lordship, in fact, now not annexed the auction notice. Because Lordship, after environment clearance,
What are the terms of the lease or agreement?
Lordship, it is for 5 years, Lordship. And the price royalty, Lordship.
Whether there was any provision
Lordship.
that if something found later.
No, Lordship, that was never a condition, Lordship. That was never a condition. That is a Lordship inform notice to every.
That is this submission you are making based on nothing. Because we have not annexed the lease agreement.
That's true, Lordship. But
we have not annexed the auction notice. There is nothing on record. So let us hear him.
Lordship.
Let us hear who is appearing for the state. You?
My Lord, I am.
Yes.
But in fact, my Lord, there was settlement of very low price, my Lord, because royalty is fixed, my Lord, 35 rupees. And additional amount is 49 only, my Lord. And in the meanwhile, my Lord, the state government has
He would
this.
not have participated.
My Lord.
Had he been knowing about it, he
My
would not have participated.
My Lord.
How can you do this?
My Lord, because the Tahsildar has decided pursuant to the letter of dated additional chief secretary and thereafter a district level committee, my Lord. District level committee decided that this will be the minimum additional price.
Whether this was made known to him.
My Lord.
For him only or for everybody?
No, for the entire Tahsil, my Lord.
So for whether it was known to him. You see that just this notice is patently illegal.
Because he
This
has
is
not
to
enclosed
intimate you
any,
that at the time of auction
my lord.
dated 11/2/2022, rate quoted was so and so,
49, my lord.
for which you have been adjudged as the highest bidder.
My lord.
However, on scrutiny of case records,
Ma'am.
case records, it has come to notice of this office that additional charge has been substantially enhanced by district level committee when at the time of grant of environment clearance based on instruction received from, what is this? 7/4/2022, this is subsequent. So we are not able to decipher anything from this.
My lord, my lord will file counter affidavit enclosing the details of the letter, my lord.
Why have you not filed till today? It is pending since two thousand
My
twenty-three.
lord, I will file.
4 weeks time is allowed for the state to file counter affidavit. So stop. We reiterate that the present rate applicant, reiterate in view of the observation made by the Supreme Court, by this court in order dated 31/8/2023. Sorry, where is that? 23, that the petitioner shall confine his prayer for quashing of the demand notice dated 24/8/2023. Yes.
My lord.
5 minutes. So on that point only,
My lord.
the counter affidavit should accordingly address this aspect. Address the petitioner's challenge to quashing of the demand notice dated 24/8/2023, bracketed annexure 7.
Item
Lordship,
22.
Sorry, Lordship. In the meantime, Lordship, what they have done, Lordship, the department has been changed. Now it has come to steel and mines. At the relevant time, it was Lordship revenue. That's why we have not never made party to the mining
Don't
office.
do it.
Now we have Lordship made party in IA, Lordship.
No, don't do anything. Let them do whatever.
Lordship. Lordship, may I pray one thing, Lordship? They have stopped my mining, Lordship.
That they can do.
But Lordship, I am ready to deposit, Lordship.
No. We have to see the legality of demand notice. also.
Lordship.
And Mr. Dalai,
Lordship.
if Supreme Court has confined your prayer only to royalty,
No,
they
High
can
Court,
go.
High
Sorry,
This court. This court.
sorry.
This court. Sorry, I was wrong. And I said. No, that they can do. You're not saying anything.
No, because otherwise it was stayed, subject to payment of so and so.
Nothing is straight.
Yes, sir.
Then let it be interim order, maybe continue,
What
Lordship.
is the interim order date?
Interim order, Lordship, 31/8, Lordship, that interim order. It is continuing time to time, Lordship.
This connected.
Yes. The interim orders will continue in the middle, subject to deposit of 50%.
In the
That's correct for
connected
us.
matter, my lords, connected matter also similar orders have been passed. This time, my lords, they have a deposit of 25 lakhs. And subject to that, the agreement will be executed and to proceed with the mining.
Where is that?
Connected to this, my
And-
friend Sweet. He has connected the second one on the list.
All right, let them file affidavit.
No, they have
Right.
already filed an affidavit and all that. I had a submission that this district level committee that the state council is relying upon, my lords, that is not also contemplated under the act. The rules do not contemplate such a district level committee to decide on the my lords, on the price.
Then who will decide? The collector.
I'm
Collector
sorry.
is the chairman of the district level committee.
So
No,
just
no.
to help him, that committee, like we have committees in the High Court also.
Collector is the chairman.
No, the auction itself has been held way back.
No, auction has been held way back. Whatever that is probably confirmed by the collector.
Yes,
price.
it has been confirmed,
So
knocked down.
this committee is headed by the collector.
Yes, knocked down by the Tahsildar is the authority, is knocked down the.
Thereafter? That I think
Thereafter,
is subject to
sub-collector is the appellate
confirmation.
authority. Sub-collector is the
Collector
appellate
is the
authority.
competent authority.
Here is
Controlling
lordship,
authority.
the competent authority
is the
and
collector.
controlling authority. The two
Controlling
terms,
authority is the collector.
Controlling authority is the collector.
two
my
terms are there, lordship. Competent and controlling. In
Sub-collector is the
consultation
appellate.
with the lordship competent authority, they will fix the price. That is the statute says, lordship. Rule says. Rule 27, lordship says how they will fix the price.
They've
Once
already,
it has been fixed, lordship.
they've already fixed the price and they've called the auction. Parties have contested the auction, participated, and their bids have been knocked down in their favor. And thereafter, they have been asked to make the minimum deposit in terms of the auction. And then they have been asked to get the environmental clearance and
No,
all other.
You have given the auction rule, that advertisement subject.
Yes,
to
I have given the
OMMC
advertisement.
rules,
Yes.
2016.
Yes, madam. Yes, madam.
You have.
That is the short point. And as it fell from your lordship, my lord, that we were not put to notice that such an enhancement would come about.
Rule 2715 is very clear, lordship. Rule 2715 is
How
very.
we will examine that? That's the question which has been.
But lordship, if they have already filed their counter, that counter may be exchanged, lordship, similar, they have filed counter. So
We
it-
don't know.
No, my lord, that is different. My lord, that is this is a case of my lord sand. That is a case of Blackstone, my lord.
law is remains one.
No, I will give that.
Issue is the same.
Issue is same, lordship. Only if they have filed counter. then-
Article 14 is everywhere, therefore one affidavit will apply in all the cases.
Lordship, the issue is the same, that's all. If they will adopt, then I'm.
No, I mean, choice is given to them. If they
Lordship,
want to
please.
adopt, we can't stop, but we can't compel.
My writ also may be confined to that demand of that year, so I have
Let's.
the liberty to file a separate.
If it is confined, no question of execution of lease by you. They can put it to fresh auction.
No, I have already executed the lease.
Now
We
they are
have
operating.
Already executed.
Executed, lordship.
So now
They are operating. my
demand-
lord.
now
No,
it's
they-
a question
now
of challenging the demand raised every year
But your prayer is execution of fresh lease.
on the same.
No, in the meantime, they've already done, lordship.
Already-
Because person entry
They
murder.
have already executed their
already done.
agreement.
This is in the present writ application. A counter affidavit has already been filed. As the points involved in the present legal issue involved in the present application is same as that in WPC numbers so and so first case. Both the cases will be heard together on the next date.
Grateful, lordship.
Great.
22.
Your Lordship, before my learned senior starts, Your Lordship, I am for the respondent. Your Lordship, kindly grant 2 weeks of time, Your Lordship, to prepare the case.
Delay we condone. The delay we condone. That matter may be exposed some other. There is a delay
Lordship,
of
delay of 300 days, Your Lordship.
71 days.
No, but you want to prepare the case so we can condone the delay and you can prepare.
Your Lordship, that IA is pending, Your Lordship.
You file an objection also.
Yes, Your Lordship.
They have filed an objection.
It is directly covered by decision of this court. And therefore you are seeking adjournment unnecessarily. Have you filed your objection?
With the con-
Yes, on delay part, Your Lordship, I have already filed objection, but Your Lordship, so far as the case is concerned, Your Lordship, I need some time to verify, Your Lordship, the case which are supporting to our case, Your Lordship. Case laws, I need to prepare, Your Lordship.
Last order, Lordship had specifically directed them to consider, to examine whether the case of the petitioner is covered by the law decided by this honorable court in Ravindra Patnaik case. That was the order, last order.
And counsel for the respondent again seeks adjournment to consider this court's decision rendered on 18/6/2024 in WA number 1193 of 2022 bracketed State of Odisha and others versus Ravindra Kumar Patnaik. Stop. For the same reason, the case was earlier adjourned. So, however, the prayer is allowed by way of last chance. This matter on 10th.
Oblige, Your Lordship.
Item number 23.
Mr. Behra? Mr. Behra?
Is fine.
Oh,
Is
sorry.
fine.
Sorry, all right.
Oblige, Lordship.
23, I have 10 days my granted, I filed the objection to the delay, my lord.
What is the delay?
Delay 121 days as per their petition, my lord.
21 days within time.
The matter relating to release of a scale of pay, my lord. Release of area salary of the scale of pay. For that reason, I want to file your objection to that case. That delay, my lord.
But here a very short point is involved. A senior assistant teacher is appointed, directed to remain in charge of the post of headmaster.
Whether you have filed your objection or not.
I not filed 10 days time, file, my lord.
21 days we are we.
121 days, my lord.
Huh?
121 days.
121. Yes, 121. This is what we are.
My lord, 121.
21 days. My number. But counsel for the appellant and counsel of the respondent. We are condoning a delay.
My
There is a delay of 121 days on behalf of the state of Odisha in preferring the present appeal. So, considering the averments made in the application seeking condonation of delay and in the interest of justice, now discretion, we consider it fit to condone the delay. Higher number so and so is accordingly allowed. The delay stands condoned. Yes.
Well, then your lordship directly serve me a copy.
That
I will
copy of letter.
In a writ appeal.
Writ appeal.
appeal memo, my lord.
Appeal memo be served upon and counsel for the respondent by tomorrow. So when do you want? 1 week?
2 weeks, my lord.
As requested on behalf of the respondent, list this matter on 2 weeks.
Oblige.
Item number 25.
Item 41 is also same matter.
Notice is 100.
Item.
Item.
41 already notice on limitation issue.
Which one?
Item 41.
Similar.
Same.
41 you are appearing.
I am in 25.
No.
41.
41 who's appearing in 41?
It's similar to 23.
Has notice been issued? Somebody
No,
is
notice-
appearing.
notice-
You are there.
Notice on limitation issue.
You are appearing.
I am also instructed to appearing, but notice.
Have you filed Vakalatnama?
I am not file in the meantime.
All right. We will see that later.
Yes, ma'am.
Okay, item 25.
May it please, Your Lordship.
41 will
How many days delay?
54 days really, my lord.
No.
The total period is 107 days.
Lordship, I
The
kindly see the
copy
SR.
period is minus 30 days. It will be around 77 days
All right.
total. But your lordship, on the other day, my lord friend has served a copy on me.
May I, my lord, place the matter?
Please. Let
One
him
at a
say.
time, one at a time.
I'm sorry.
Your lordship, there is no merit on the, your lordship may hear in the merit of the case also.
Here
While
only
condoning
after condoning the delay. We can hear after condoning the delay. We will hear on merit after when we are here considering for admission.
pass order because these people are the advertisement in the year 1955, 1516, they were selected person securing less mark than the petitioner
have been given appointment, learned single judge, asked the OPSC, how you could give appointment to these candidates, those who have secured.
Just think of our problem.
Yes.
The appeal has been filed by him. He could not open his mouth. You spoke on the limitation. We are inclined to condone the delay.
Oblige, Your Lordship.
Then you have started making your submissions on.
On the other day.
If you accept his brief, then we will allow.
Oblige, Your Lordship.
No, and after we condone the delay, we can hear you next date.
Oblige, Your Lordship.
All right. We are just coming.
IA for condonation of delay. Sir, have you received a copy?
Yes, I have.
Yes. So Upendra Kumar Samal, Learned Counsel, has appeared on behalf of the sole respondent.
Respondent number, there are two respondents.
So you appeared for both?
No, for one. Respondent number one. The other respondent is the state.
All right, has appeared on behalf of the private respondent number one, respondent opposite party number one. There is a delay of 77 days. Or what is the stamp report has shown? 52 days in filing the writ appeal. Considering the averments and the application for condonation of delay, and in the interest of justice, we are satisfied that it is a fit case for condoning the delay in filing the appeal. The the delay in filing the appeal is condoned. The IA is accordingly allowed and disposed of. So admission, we'll keep it next week.
Let's keep this matter to next week.
Next week. This for fresh admission on 10/7/2024.
Let me keep it on 11th, my lord. I have some difficulty on
11/7/2024.
Item 26. Item 26.
26 mile. My revoked. 26.
It's the same matter.
So say along with writ appeal 1330, so along with that other one.
Item 27.
Item 27, I am appearing for the respondent. I have already filed my power. The power has not come. And moreover, the delay of 130 days. And a copy of the appeal memo is supplied to me so that in the next date I can apply your lordship.
So delay will condone.
130 days.
130 days.
State of Odisha.
Yes. And the
So the
same
same-
matter is already disposed of by division bench of the Honorable Court. Up to next date, I will apply, let a copy of the appeal memo is supplied to me so that.
It is same order, Khali Mr. When did you file your wakalatnama? Last week. Last week. Mr. Sushant Kumar Joshi, Learned Counsel, submits that he has already appeared for the
Respondent. Sole
respondent
respondent.
number one opposite party by filing wakalatnama last week. Eta IR lekhiwe hala. The same thing. There's a delay of 130
days.
days in filing the writ appeal. So considering the averments and the IA for condonation of delay, and in the interest of justice, we are inclined to condone we think it to be a fit case for condoning the delay in filing the writ appeal. The delay is accordingly condoned and the IA is allowed. A copy of the writ appeal be served on Mr. Are you going to serve it here or later? You have a copy?
Day after tomorrow.
Copy of the writ appeal be served on Mr. S.K. Joshi, Learned Counsel, appearing on behalf of the respondent number one. This is the case for fresh admission. Copy shall be served by 12/7/2024. This for fresh admission on 10/7/2024.
No, 10th, third week, 22nd.
16.
23rd is 22nd.
What is the problem?
Madam?
What is the problem?
I have to shift, madam. I have to.
Shifting your office?
Aye.
All right. This is the case on 23/7/2024 for the 24 for fresh admission.
Like,
182 days. 182 days.
Item 29.
Your Lordships. My Lords, the applicant is an old lady of 67 years. She has a,
Old lady of,
my Lord,
old lady of,
67 years.
so you'll become old after 5 years.
And she has challenged two orders of the single bench, single judge.
Two
One is
orders.
pending and another is disposed of.
The same writ appeal, you have challenged two orders.
Two orders. The pending case is the review and the decision taken in WPC number 2655 by 2022, disposed of on 17.
Review is pending.
My Lord, one is pending. So both the orders are challenged.
So if it is
Because the review is now pending for a compromise. But it is not compromised.
So if it is pending, what are you challenging the order passed in the review?
It is being delayed.
No, but
I have instruction to appear in this case on behalf of the sole opposite party bank, that this is the matter because the appellant before your lordship is the wife of late Samaru Meher, and he had opened 3 accounts in our bank, and there are 2 savings bank accounts and 1 fixed deposit account. In that fixed deposit account, the nominee was his nephew, and the other 2 accounts, savings bank accounts, we have handed over the copy as per the direction of this honorable court. We have handed over the money to the present appellant. The third one, when we came to know, and the third one, when we came to know that his brother-in-law is not the nominee, his nephew is the nominee. So we want to review the order by filing a review application stating that the nephew is the nominee and not the brother-in-law. So that order was modified, and the court thinks it right to implicate him as a party, the nominee as a party. So notice was sent to nominee, and nominee appeared. After appearance of the nominee, the court thinks that the nominee should get some money, and what is the compromise between you? Let him say that the nominee said that because as per the 84 Supreme Court, the nominee has a limited right only to draw the money. The legal heir will have to get the money. So that we have stated before the Honorable Court. Then the Honorable Court said, no, you make a compromise between the nominee and the legal heir. That in this juncture, we have challenged that order before this Honorable.
Talking of brother-in-law, but she's a woman.
No, woman is the aunt of the present nominee. No issue. Only the wife. There is no legal heir except the wife.
Wife. The wife should get it.
Wife is entitled to get.
She's the wife or not?
Yes, he is the wife.
Which matter is pending?
The review is pending, my Lord.
No, review has already been disposed of. Review disposed of with a direction.
No, your review is disposed of.
You don't.
Without, my Lord.
You have come here to address us, not him.
Sorry.
So what is your grievance?
A review petition has been disposed of, Mr. Counsel.
Is reviews pending?
Oh, you have also filed review.
Yes.
You have filed review.
But his review was allowed without issuing any notice and violation of natural justice. So my client did not know what is the review about.
That review, he had appeared and he was hard.
My Lord, the opposite party bank has filed an objection saying that there is no violation of natural justice.
So you pursue your review application. You
No,
can
no.
pursue your review application.
I will do that. But as said by Mr. Mishra, that the nominee is claiming some money. But 1984 Supreme Court says that nominee is only a custodian.
but he has no right to claim any price.
Right.
So how the money will be paid to the nominee? So in that stage, the matter is pending. Your lordship may dispose of here.
My
Dispose of.
my lord, may I clarify the things which is confusing your lordship?
No, nothing is confusing.
That
What
that
is
both the
matter is
review have
pending?
been already been disposed of. In the last review, there was a direction by the honorable court that the wife will get 70% and the nominee will get 30%. That was the order.
It is your
Because
statement.
that was the compromise between the nominee and the legal heir. Nominee is the nephew of the depositor.
He is not in legal.
That was the compromise between them.
My lord, I humbly submit that the first order passed by the single judge, that the petitioner is entitled to get all the money deposited in the bank. But the learned counsel for the bank
Will I review?
held a review
Stating
cha-
that,
changing the mind of the single judge.
what do you mean changing the mind?
Mind says he objected against me that Mr. Naik wrongly implemented a wrong party.
So isn't that correct?
No, it is not correct.
So the nominee was not the,
Nominee was
Nominee,
not the party. That's why this honorable court think it's proper to add him as a party. Notice was sent to him. He filed objection. He was heard and he was also heard. And both the reviewers disposed of. At the time of disposing the second review, this honorable court thinks it proper that since you both have come in compromise, 30% will be given to the nominee and 70%.
all right, now we have understood. Now he is saying he is not agreeable to the compromise.
My lord.
So, no, but why did you compromise the matter?
Because he was not paying.
My lord, it is the statement of my petitioner
Huh?
that I am very old and I may not survive for some more days. So, if honorable court says for compromise,
Then very good. Stick to that.
of course I agree, but why it is being delayed? Because the nominee is claiming more and more price. Why?
They have filed 2 interim applications, which are pending before the honorable court for adjudication. In the meantime, he filed this writ appeal.
Court has already settled the problem.
Where is that order?
My lord, annex page 15, my lord. 15.
If that is the case, he is agreeable to that compromise, then why is the case pending?
Because it is between them.
My lord, that is
We are not disputing what the court passes order, my lord. The court passes the order that 30% amount
you are
will be
also,
given to the nominee
you are also
and 70% will be taken.
Don't.
It is your claim, it's not the client's claim. Internationally.
Sir, let me understand.
Page 16, my lord.
Please, let me understand. You have filed a writ appeal. You have filed a writ appeal against which order?
Against the order dated 9/2/2024.
All right. So where have you mentioned? Where is the order?
Page
Dated
16.
9/2.
Page 16.
Where have you said? Where is the order? Have you annexed the order?
Yes, it is quoted, my lord. Entire order is quoted. Page 15, paragraph 3. It is, my lord, I am reading.
See, it is not easy for us to understand.
My lord, I am reading the order. What is the order about? It is, Mr. Naik, learned advocate, appears on behalf of the
You don't have
review
to
applicant.
read the whole order, mister. That order was passed. Thereafter, a review application was filed. The review application is, what is the number?
Number 230.
Huh?
My review number is 198 of 2023.
No.
Age review case number is
Oh,
213 by
just
2.
a minute.
Wrong.
It's impossible for this. Come
Our
to page
case was
22.
119 and his case is 230.
Come to page 22. Annexure 2 is what?
My lord, 22.
22 is the order passed on writ petition.
Yes.
No, read the first sentence.
Review applicant was writ petitioner.
So this is on review application.
No, it is not, my lord. It is not a review petition. It is a IA. In interlocutory application, your lordship, IA number 15541. With the learned single judge has set.
So you have not annexed the order of this court. Let us think over. We will do our homework.
My
And
lord,
then we will come back.
my
to
lord,
you tomorrow.
only problem of the petitioner, appellant, that he will get the third one deposit. Third deposit. Two deposits are already disbursed.
Mr. Naik, we understand there is some problem, but since you are not able to explain to us what has happened,
And
we have
we
to
are
go
not
to
able
the
to
brief.
understand. Therefore, we will try to understand and then we will come back to you tomorrow. All right. And we will address you.
Let him serve a copy on me, man.
Your lordship may issue notice.
Then it will take a longer time. You prefer that? You want that?
Your lordship may
I
issue
thought
notice.
I
I will serve a copy to Mr. Mishra.
Please tell us what can be done in this case. Please tell us tomorrow.
Let him serve a copy on me.
Mr. Naik,
Next week.
if you serve copy, then it will take time. So if you want an early disposal, serve a copy.
My lord. Because another party is there.
We'll
The
see,
nominee,
we'll see.
the nominee is there. Say,
We'll see, we'll
he will be noticed.
Yes, if necessary, he'll be noticed.
He is not a necessary party. I'm sorry.
All right.
Copy of the writ appeal is served.
I will serve the copy tomorrow.
All right, all right. You don't have
Only one copy is
extra copy nahi pheri diyo.
Tomorrow.
आइए for condemnation of delay.
Tomorrow I may get.
That should be condoned.
That your lordship knows.
No, we'll see what the matter is about, what you have challenged, what you are
Related to
not able to
condone,
understand.
whatever limitation is there. Your lordship condone because the old lady, she has no capacity to come to this court.
But you have the
He is
capacity.
a man of a Sambalpur.
You have the
But the
capacity.
capacity to engage him also.
We will do something.
You know the background. Without the appeal memo also, you can assist.
Next week.
No, tomorrow.
Notice.
Tomorrow we'll
Tomorrow
see.
we will see.
Tomorrow.
Tomorrow.
We will examine the
Let him
record.
serve a copy.
He doesn't have a copy.
See, sometimes we have a duty towards the people also.
Tomorrow at 2 p.m.
Tomorrow it will be.
Item number 30.
Lordship, in item number 30, may I address virtually?
Please do.
Lordship, I am appearing for the opposite parties number 2 and 3 in this matter. In by way of your Lordship's order, order number 16 dated 24th of April, your Lordship had directed the petitioner to approach IDCO afresh for granting a lease at the present market rate. He did so, and IDCO also took a decision and communicated it to him. IDCO also filed an affidavit before this honorable court on the 26th of June, communicating its decisions. Challenging those decisions, the petitioner has filed an affidavit just on 30th and served it upon us yesterday at 1:30, somehow disputing that decision. I have communicated it yesterday forthwith to my client, and I request only 1 week's time to get comments.
Those affidavits are not there on record 26. You want it. All right. Mr.
On behalf of Mr. Gautam Mukherjee, I am Mark Wright.
Mr. Mark Wright, learned counsel, appearing on behalf of Mr. Gautam Mukherjee, senior counsel.
On Mr. S.D. Rai, behalf of
On-
Mr. S.D. Rai.
On behalf of Mr. S.T. Rai, learned counsel, appearing on behalf of opposite party number
2 and 3.
2 and 3, submits that the petitioner, in accordance with order dated
24th of April. 24th of
24/4,
April.
2024 of this court, had approached IDCO
IDCO.
with his offer, or something had been fixed
Yeah,
to,
with a
proposal,
fresh application.
with a fresh application, and the same has been considered by IDCO, and the decision has been taken.
The decision has been taken and communicated to them, and also
Okay,
an affidavit
okay.
has been filed by
Decision has been taken which date?
Lordship.
Decision has been taken on so and so date and communicated to the petitioner, and an affidavit has been filed on the 30th June 2024, enclosing these documents.
No, no, reply to that affidavit, I have.
Yes,
on-
we have not come to that. So wait. That, and in reply to the said affidavit, an affidavit has been, have you filed that affidavit, only soft copy?
No, they have served copy.
Your affidavit,
I have served, yesterday I have served.
you filed it?
Yes, yeah, I filed it and served.
All right. An affidavit dated,
30th.
30th.
no, that is their affidavit, your affidavit.
My affidavit is 30th June.
That
Their
is 30
affidavit is that I received on 26th of June.
What, your affidavit is dated which date? You said you have filed it on 30th?
Date.
30th.
You said 30th, no? 30th. In reply to that, and
26, 2020.
Reply I have filed and served copy.
you also filed on 30th.
On 30th June, I have filed
Acha,
the
the
reply.
petitioner has filed an affidavit on 30th 6, 2024, serving copy on the counsel for opposite party 2 and 3, for which Mr. Wright prays for a short adjournment. Mr. Wright, learned counsel, prays for a short adjournment in order to obtain instructions. This the case on 1 week is fine, or you want
Yes,
more?
Can it be more? Can it be after 17th of June, my lord? Because Mr. R.K. Mahanti, senior counsel, has got some personal difficulty.
List the case on 18th. will-
After 17th.
18th or 25th? Okay, on 24/7/2024. All right.
Obliged. Deeply
Interim,
obliged.
interim order to
Interim order passed earlier to continue till the next date.
Deeply obliged.
How they have offered you?
They have offered the value of sale and purchase, outright sale value they have.
All right. That was your,
No, the industrial area price is something different, my lord. They
you
have,
are going to
they
establish
have
a
fixed,
hotel.
no, they have
They
fixed that. They have themselves fixed that.
They have fixed for, they are asking you to pay 44 crores.
44 crores per acre, they have fixed on the sale, purchase and sale price.
Well,
And the industrial, this is a lease, my lord, lease of the industrial area plot, my lord. The price is different, my lord, and they have fixed themselves that 15 crore. I have annexed those documents.
15 crores recently.
On 2019, they are following that.
19 and you are in 24.
2019.
And then you have to establish your business. If you are interested, then you can do, otherwise you can leave.
No, they are giving
They may
much.
decline.
Huh?
They may decline and the court may refuse to interfere in such matters. Make a decision. They have offered something. If they
Outright sale value, they have given that.
outright sell, they can sell. Just think of, they can give the same plot to some other.
No, because
operator.
they lease out this property on payment of premium and take ground rent also 1% of that
That you
yearly.
can-
No, because once we decide, when we consider it on merit, if we think that either you take it or leave it, you may lose your chance to get
And
that
just
plot.
think of if there something can be negotiated, to resolve it.
Lordship, I will take full instructions.
Affidavit filed on behalf of the petitioner shall be brought on record. Nahina said. नहीं नहीं ऑपोजिट पार्टी रोज petitioner को आपको देखा है, लिखा है। हाँ हाँ ठीक ठीक
Item number 31.
Union of India will argue this matter because we already argued.
yes yes there.
Yesterday.
Where is Mr. Behra? Yeah, there.
But I am appearing for the Transport Commissioner. May I submit certain provisions under the Motor Vehicle Act and rules. But here the rule 81, so far as the additional fee is under challenge, on the ground that the similar notification was made in the year 2016, was struck down by the Honorable Madras High Court as well as this Honorable Court. So subsequent notification made claiming the same clause fixing the additional fees. The sole argument before the Honorable Madras High Court was that there is no substantive provision under the parent act, that is Motor Vehicles Act. So the fees is without authority of law. So may I place certain provision under the Motor Vehicles Act so that it can be, whether that there is provision or not, that can be canvassed. But may I place section 39 of the Motor Vehicles Act provides for necessity for registration. I will not go entire section, but that chapter started with necessity for registration, chapter 4. And section 41 provides registration how to be made. Section 41 of Motor Vehicles Act.
Yes.
May I place subsection 7, 8 and 9. Subsection 7 provides a certificate of registration issued under subsection 3, whether before or after commencement of this act in respect of a motor vehicle, shall, subject to provisions contained in this act, be valid only for a period of 15 years.
You are reading?
Section 41 of the Motor Vehicles Act.
Yes,
Which motor vehicle?
Subsection 7. Yes, only one
Yes,
Motor
yes,
Vehicle Act.
Which subsection?
Subsection 7.
Yes.
The validity of a registration certificate in respect of a motor vehicle, which provides once the vehicle is registered, be valid only for a period of 15 years from the date of issue of certificate. Then subsection 8, an application by or on behalf of owner of motor vehicle for the renewal of a certificate of registration shall be made within such period and in such form containing such particulars and information as may be prescribed by the central government. So subsection 9, an application referred to in subsection 8 shall be accompanied by such fees as may be prescribed by the central government. Or Lordship may see such fees. The fees has to be prescribed by the central government. The renewal of application for registration that has been provided under section 56. Sorry. Fitness certificate. Renewal of registration.
Please take your seat. Page, section
But
56.
Not central motor vehicle rules, rules 57.
57.
57. Rule 52, sorry, rule 52. Renewal of certificate of registration. So an application by or on behalf of owner of motor vehicle other than a transport vehicle for the renewal of certificate of registration shall be made any registering authority in the state in which the vehicle is in Form 25 not more than 60 days before date of expiry, accompanied by the appropriate fees as specified in Rule 81. So Act provides the renewal of registration shall be made as prescribed under the Central Motor Vehicle rules. And here the date, the time limit has been prescribed, that is not 60 days before its expiry. Then our Lordship kindly see section Rule 81 of Central Motor Vehicle rules.
Rule
81 of Central, which is under challenge.
So what is the date of the judgment of Madras High Court?
But in the year 2000. 2017, judgment. 2017. That is the date 3/4/2017. I am passing over the judgment of the Madras High Court.
Yes.
Not Rule 81.
Yes.
Prescribe the fees for renewal of and registration fees
Yes.
yes, but issue of register, that is clause 4, item number 4. The issue of certificate of registration and assignment of new registration mark. And the note is in the bottom. In case of delay in applying for renewal of certificate registration, an additional fee of 300 rupees for delay of every month or part thereof in respect of motorcycle and 500 rupees for delay every month or part thereof in respect of other classes of non-transport vehicles shall be levied. So there is time limit to make an application for renewal of registration. And
Which part you are reading?
I am reading in the bottom that rule.
81.
Serial number 4. It starts with the issue of certificate.
We have seen. Note also. One.
Rule 81, the table. But it may not be there in the Central Motor Vehicle rules.
Additional fee of 200.
Additional of fee of 200, that is in respect of smart chip card.
We are reading.
Yes.
You are referring to note 2.
Note 2.
Yes.
Note 2 is not here in this book. So, okay.
You have to say Odisha, you will need to.
But in that,
Page 589. So this note 2, when did it come into the statute?
That
21?
that is not 4/10/2021. No, 16/7/2021.
Not mentioned it
That is the
properly.
notification which is under challenge.
No, no. This was existing. Now that 50 rupees,
That is in respect of this is
notification.
no.
2016
This is for renewal of
2021.
registration. That 50 rupees in case of renewal of certificate of fitness. That is in the next page.
That is 11.
There are two additional fees.
That is 11, my lord. Serial number 11.
but they, I think, are sticking to one or both.
But
You are challenging both.
yes,
Both fitness and re-registration.
Okay,
both.
the renewal of registration
That
and fitness.
notification in my case.
So this
first-
note 2,
Yes,
earlier it was additional fee of rupees 300 per month. They are challenging
So
this.
you
and this.
want us to quash this?
Well, there are two notifications. 2000 note, you lordship that book, 2016 notification there. In my read application, the new notification is there of
Of?
2021. Yes.
We have found it. So that 300 rupees.
Motorcycle is 300. And four-wheelers.
So that 2021 notification is being
Yes,
challenged
yes.
already.
16 is the same thing was there. In
So wait,
2006
wait.
notification.
No, but if we remove it,
My lord.
then what will happen?
Will pay the enhanced fees, whatever fees will pay. So for this
No question of enhanced fee.
fee already is announced.
Lordship, in
This
that
is there,
table, serial number 4,
Hmm.
Lordship may find renewal of registration in respect of different vehicle, that fees has been mentioned. In the top A, invalid carriage, 50 rupees. Lordship may find
Where is the provision for applying for renewal of certificate of registration?
My lord,
Yes,
there
Lord,
is
that
a
is-
form, there is available form is there.
Where is the provision? Form is the
Pro-
form must be
provision is that-
under some provision.
Yes.
Lord,
Yes,
that
that provision.
rule 52 of Central Motor Vehicle
Central Motor
Rules.
Renewal of certificate of registration. will be fitted to-
Rule 52 of Central Motor Vehicle Rules.
That is chapter 3, my lords, register motor vehicles.
52A.
Rule 52 itself.
Central motor vehicles rules, my lords. Renewal of certificate of registration.
All it. Yes.
May I place that provision? Rule 52. But an application by or on behalf of owner of motor vehicle other than a transport vehicle for the renewal of certificate of registration shall be made to any registering authority. The vehicle is in Form 25 not more than 60 days before the date of its expiry, accompanied by the appropriate fee as specified in Rule 81. Similar, that fees has been prescribed. There are two fees. The normal fees for renewal of registration, that
So
fees has
this
been
is what we want to know.
That is a my lord, fee and additional fees. These are two terms, my lord.
Mr. Counsel, if we hold that part of Rule 81 to be ultra virus void,
To total not, up to the extent of additional fee. We don't say that entire ultraverse the rule 81. Only
Alright,
to the
all right,
extent of
all right.
additional.
Where
fee,
is the provision for making delayed application?
Delayed application, there is a rule under the Orissa motor vehicle rule. There is provision. I have already quoted that is I have already.
So that is not there under the central.
No, that is delayed for, there is a rule. Orissa rule is there. Orissa motor vehicle rules
We are
1993.
again putting this question
My lord.
that central motor vehicle rules prescribes a time limit
60 days.
for making an application for renewal of registration.
My lord.
It is there. There is no provision for delayed application.
Delayed application.
All right. So according to you, the Odisha has provided.
Orissa motor vehicle rules 1993.
Very good.
There is a provision.
Where is that?
That is, your lordship, that is rule 34, my lords. Orissa motor vehicle rules 34, your lordship.
Before that. Yes, rule 34.
My lord, 34.
34 will be page. Yes.
Charges for delayed registration or renewal. Rule 34. Sub rule 1, my lords. If the owner of a vehicle fails to make an application for registration under subsection 1 or for renewal of a certificate of registration under subsection 8 of section 41 within the periods prescribed under rules 47 and 52 respectively of the central motor vehicle rules, the registering authority may, having regard to the circumstances of the case, require the owner to pay in lieu of any action that may be taken against him under section.
So whether this provision is contrary to the provisions under the central motor vehicle rules or not?
No, not contrary matters, because under section 65, their power has been delegated to the central state government to frame the rule. There is a power, my lords. That power is delegated, my lords. Under
Let us
section
see to what
65.
extent.
Section 65 of the Motor Vehicle Act, my lords. 64, that is, power has been delegated to the state central government to frame the fees, and 65, my lords, that is delegated the power to state government, my lords. Section 65. Stand. 65, power of state government to make rules. This is coming under chapter 4, my lords. A state government may make rules for the purpose of carrying into effect the provisions of this chapter other than the matters specified in section 64. So whatever the matters specified in section 64 for
What
the central
about
government.
64A?
So 64 and 65, these two are vital sections. Section 64 empowers the state government and central government to.
Okay, there.
No, no, small.
That is Motor Vehicle Act 1988, my
I'm
lords.
just checking that has to say 41. Registration. Specify the period.
There are 65. D, my lord, 65 clause, subsection 2, D. The issue or renewal of certificate of registration and fitness.
Look at 64F.
64, my lord, 64. not-
64F.
The form in which the application referred to in subsection.
E, A and F.
There is a form is prescribed under the Central Act.
See.
Mr. 64 EA.
The period of renewal of certificate of registration of different types of motor vehicles. That is 60 days or that is the different periods are prescribed, my lords.
F towards the end, fee to be charged.
Fees, oh, 64, oh, my lords.
F. The form in which the application is to be made,
Form in which the application.
particulars and information it shall contain, and the fee to be charged.
Fees fixed under section rule 81, my lords. And 64, that is the power delegated to the central government to frame the rule, my lord. Your lordship may see section
Okay.
64.
So why are you not seeing this EA and F? Let us understand. You may be correct, we may be incorrect, but let us come to this 64 EA.
The period of renewal of certificate registration of different types of vehicles under subsection 10 of 41, my lords. Your lordship.
The
Section-
period of renewal is for the period the certificate is to be granted.
Yes.
Okay, then F.
F is the form in which the application referred in subsection 14 of section 41 shall be made, the particulars information shall contain and fee to be charged. That is a form. The form is available. That is the application form for renewal, my lords. That is,
So this power is vested in the central government.
yes,
So the rules on these points, period of renewal of certificate of registration of different types of motor vehicles and the form in which the application referred to above shall be made, the particulars and information contained and the fee to be charged. This is within the domain of the central government, the
yes,
state
fee-
government.
The domain of the central government is fee. Fee
Yes,
is to be fixed by the central government.
yes,
But my case, we are at additional.
we
fee,
understand that.
Fee addition.
We understand what you are saying.
my lords.
Your case is that additional fee is not in the nature of fee, rather it's in the nature of penalty,
My lords.
which cannot be imposed as has been held by Madras High Court. This is your
Other high court,
submission.
our own high court and several high courts also there,
Yes,
judgments.
and you are relying on the rules framed by Odisha state government.
And there is no rule regarding additional fee, my lords. No, neither in Odisha or in central statute, absolutely there is no regarding the additional fee, nowhere is there.
No, but a little while earlier you were saying that the power vests in
Power,
the state
my
government.
response submission is under section 64O, the Union of India can exercise.
All right, we are simplifying the issue.
My lord.
If you are required to file your application for any examination within a particular date, university examination. All right. And a fee is prescribed, examination fee. Now it further prescribes that if you don't file this application on such and such day, you may file the application by such and such day, subject to payment of additional fee of so and so.
We call it late fee.
So
or
therefore,
something.
because there is no provision for additional fee, therefore that cannot be imposed.
That is already state is
The
claiming, my lord.
additional fee is as simple as that. It is not doing, it does not do anything. It just creates a circumstance where you file your applications within time. Otherwise, yes,
But for that, my lord, state is collecting
for that.
delayed
yes,
application
Right.
under 34.
Right.
Under rule 34, state is collecting.
Yes, yes. We will have to deal with that.
Yes.
Therefore, we are here.
Because rule 34 prescribed and also rule 22(7) for fitness, they are collecting additional fee.
Knowledge. So we have understood your
34.
submission.
That
Yes.
is the penalty. That is the penalty clause that rule 34, Lordship may find that
No, you make your submission. Listen.
similar, there is.
Oh, you don't have chair. Why?
God, sad.
Please, just come. Please come here. Take chair. Give him a chair, please. Give him a chair. What is this?
Similar, there is substantive provision under the act, and accordingly the central government has notified that additional fee by amending the rule 81 of the central motor vehicle
When
rule.
did you amend?
But,
When did you amend?
Central government.
the
When
amend,
the central government amended the.
that amendment, annexure 5, in,
So you are for the state government,
yes.
but all the same you support the,
Yes, we are the executive, we have collected the fees, so I am supporting. I have not filed counter, only to show that relevant provisions.
No, whether counter affidavit has been filed.
In the central government has filed.
One counter.
One
So-
case, my lord.
central government has filed.
Yes, my lord.
One WPC 34108 of 2020.
All right, so you are challenging their this thing, and then therefore we will hear him.
My lord.
What is the additional fees that my landed senior is raising, my lord? After 2016 notification, which was been washed by this honorable court, my lords, the central government came up with a scrapping policy. The sole intention is, my lords, which I got, your lordship has directed me to take out all the instruction and the exercise that central government has done. Why 21 notification has to come, even though in 2016 the same identical notification was quashed, my lords. My lords, the scrapping policy came into force because of the fact that after 15 years, my lords, the data which has been collected, that the vehicles, if they are plying on the road, the pollution is more than almost 10 to 15 times. That is why, my lords, the fees and delayed fees were charged to renew it, to get the fresh fitness certificate.
So the logic which you are giving now,
Yes,
that was not available when the earlier notification was quashed.
my lords, in 2019 there was an amendment, and my lords, thereafter the scrapping policy came, my lords, and this fact was not dealt with in 2016 judgment, my lords.
Can't be dealt with because it's not there.
Yes, that is what my humble submission. So, my lords, the 50 rupees additional fees for per day is being charged in order to put a condition on the vehicle owners to bring their vehicle back for re-registration at an early stage, although there is a provision for delayed payment, which is a fixed payment, my lords. That is the only submission, my lords, insofar as per day charge, because they cannot keep their vehicle for indefinite period and then, my lords, pay a fixed delayed charge and get it renewed.
So why have you met that provision? You could have just let down that there shall be no renewal.
Sorry.
You could have refused registration.
You could have refused re-registration.
Yes, ma'am. That
or renewal of registration.
My lords, then that would create a chaotic situation also.
What?
Because if the registrations are refused.
See, there was the same provision which was there earlier.
My lord.
That was passed by the High Court.
My
That is a real ultra virus.
Yes.
And then again you have introduced. So if you have introduced,
yes,
you cannot defend that
my lord,
based on any factual aspect. You will have to demonstrate the legal backing.
Yes,
what is the backing?
Well, backing is, my lords, your lordship, subject to your lordship's appreciation, my lords. The scrapping policy and, my lords, before introducing this 21 notification, objections and suggestions were called for, my lords. And thereafter this notification.
Then you don't have any case. Then you don't have any. See, why was the provision declared ultra virus?
My lords.
Why?
My lords, if I may place that, my lords, that part of the.
Yes.
Yes.
And whether there has been any change
my lords,
from that situation.
My lords, that change in circumstances.
Statutory, no
yes,
factual.
My lords.
Statutory.
My lords, statutory, just now my learned senior submitted in 2019 note. There was an amendment to the statute, my lords, where, my lords, I'll place that. Your lordship will have page 43, my lords, where our High Court has given the reason, my lords. The parties are directed to abide by the decision of the Honorable Supreme Court, since the central government has already challenged the impugned judgment of Madras High Court. They are not required to challenge this order. However, the petitioner wants to intervene. If the petitioner wants to intervene in the application pending before the Honorable Supreme Court, it is open to the petitioners to intervene and prefer appropriate application to plead the case before the Supreme Court, taking into consideration the huge filing of writ petitions by the litigants. Only this issue, on this issue, more than thousands of matters are pending. Every week, hundreds and hundreds new matters are coming on board. The division bench has to engross in these matters in view of the observation made in Madras High Court in Chennai City Auto Supra. Since the Honorable Supreme Court has not stayed the judgment, we are of the opinion that the impugned notification, particularly entry serial number 11 in column 3 of note of the table of to Rule 81 shall not be implemented at present within the state of Orissa. This is the only reason was mentioned.
And the petition was disposed of.
Yes, ma'am.
There is another judgment that is struck down, my lords. Second judgment I have given an example that is struck down. That rule has been struck down. That is there, my lords.
In your writ petition, it is there.
Yes,
You
my
keep it
writ
separate.
application I have annexed.
Both the judgments,
That
has
is
been
struck down,
delivered,
my lords.
but without considering the merit of the case. And
Not
this
yet.
honorable court has struck down, since the Madras High Court
That
has
is
struck
Annexure
down that
4.
provision
My
in
lords,
view
my
of
writ-
Article 226(2) of the Constitution of India. Since it is a parliamentary legislation and one High Court has already been struck down, then it applies whole of the territory of India. In that view of matter, this honorable court disposed. But on merit, that has not been considered.
Yes.
So far, my lords, scrapping policy that is came into force in the 2021.
That is-
Thereafter, this notification is issued, my lords.
Our High Court judgment, my lord, and giving my. Dinabandhu Saab case.
That is there, annexure 3.
Yeah. अच्छी record is edition that is. Okay.
So how do you say that this court has considered the matter on merits?
No, Lordship,
How do you
annexure.
say? How do you say that this court has decided the question of additional fee on merits?
That both, that it is struck down, my lords, your lordship is.
Paragraph 6,
Yes, yes.
only Madras High Court.
The second judgment, my lords, your lordship is Annexure 4. That is Aniruddha Kumar Das. That is the second judgment, my lords. Yes. That is running page 55, my lords. Internal page 9. That is paragraph 13, your lordship. After considering the entire fact situation of the in the instant case and submissions made by the Honorable Counsel for the parties, and after considering the paragraph 18 of the judgment of the Madras High Court,
Where are you reading?
that is page 54, my lords, running page 54 of the first writ application.
Same thing, same Madras High Court.
Yes. And therefore, to maintain the uniformity following judgment of Madras High Court, we also consider it appropriate to struck down the amended rule 32 and 81 of the rules. Amended by notification dated 29/12/2016.
So subsequent to amendment, there is no judgment.
That judgment, that is, I have given my lord, that is the Karnataka High Court.
Karnataka.
That is order. Struck down. And also Kerala High Court, I have given in the interim stage continuing till today, since
Kerala.
2022.
Karnataka.
Karnataka, and there is Ernakulam bench I had given also. I have a copy also. That is-
Nakulam is not Karnataka. Where is Karnataka?
Karnataka, just I have a copy also.
Kerala.
9176. Wait, give us the judgment for this court and Karnataka High Court. Where is that decision?
I had already supplied.
9176, my lord.
This is one copy.
Is it there on?
Already there, my lord.
Yes.
No, yes.
ଦେଇଥିଲି ରକ୍ଷା ପାଇଁ କାଲି ଦେଇଥିଲେ ନା କଣ? କର୍ଣ୍ଣାଟକର they had given yesterday, I remember.
Second copy.
No, this is not a judgment.
That your lordship, para 3, my lord. Is very important, central government.
Order,
That is the submission of the central government.
order.
My lord.
This is not judgment, order.
What is the order?
Again, Madras, paragraph 2.
My lord. But central government, my lord, conceal that your lordship. My lord,
And
order.
in Karnataka, single judge is decided.
Yes,
Single judge,
that-
honor.
Huh?
Single judge, sir.
The virus of enactment is decided by single judge.
Power and between the
That must
your
So
lordship.
they've challenged the notification, so they've.
There is no modification.
No, here. To avoid the- Again, Madras High Court.
So,
Again, Madras High.
And this is
Your
short-
lordship, Madras High Court is the
and this is
main
short-
picture.
shorter than our High Court's.
Your lordship, we are waiting your our High Court's order. My
So
lord is-
our High Court has not considered the matter on merit and the judgment of the.
the larger question which we are facing
Mine.
is whether we should decide the matter on merits or because the division bench of this court has decided, referring to the decision in case of Madras, we should follow that. That is the, we too sometimes are in dilemma.
But your lordship, what happened?
But in the recent development,
Let them not collect the additional fee.
We don't know.
Your lordship.
but in the recent development, the Honorable Bombay High Court has delivered a judgment on that point, my lord, where both the High Court, our High Court and Madras High Court has not considered section 211 of the Motor Vehicles Act. That is the power.
File or अपने scan होनी है, what is the use?
Six.
Judgment पर scan ना होने रखी फायदा नहीं.
And same rule has been questioned
Same.
before
What was that?
Honorable Bombay High Court.
16 my lord, notification, not a new my lord.
PL?
Bombay High Court.
It's regarding DL or both?
No, my lord, that
Both.
both the rules, Rule 32 and 81.
Yes.
And paragraph 24, their lordships has held that the Madras High Court has not considered the paragraph 24.
Yes, so Bombay is against you.
Yes, that judgment is there. Bombay High Court judgment there. That has been old notifications of 2016 that is challenged. There, my lord, section 211, this, so for this present notification is concerned,
this notification has been issued under section 64, my lords. And that notification has been passed under section 110 of the MB Act, which has no application at all. So that notification has no leg, my lords.
See, notification may not be any legs, but what the Bombay High Court says
My lords,
that
that
section
section
211
211.
of the, it gives power to the central government to make rules providing for levy of additional fee.
No, 211 only fee.
Only
Section
fee.
211.
Only fees,
Section 211.
211.
They interpreted, my lords,
They
that interpreted that it can be dealt as additional.
No, see, this is view of Bombay High Court, that Bombay High Court view may be incorrect, but this is the conclusion, paragraph
Yes, that is,
28.
I have gone through that judgment, my lords.
Yeah.
That judgment relied on two judgments of the apex court, my lords. One is Sona Chandi case and another is, that is Jalakal Vibhaga Nagar Nigam, that is the latest judgment of the apex court in 2024. There, my lords, tax and fee has been decided.
No, they have
But they relied on two judgments of this court, that apex court. Your lordship, I am placing that.
yes,
Paragraph 26.
those judgments were pressed by the petitioners.
Not petitioners, my lords. Those judgments have been issued by the Union of India. Those judgments have been placed by the Union of India. Paragraph 29, your lordship may see. In view of the law laid down by Honorable Supreme Court in the case of Sona Chandi, Whole Committee and other Supra and Jalkal Vibhaga Nagar Nigam Supra, the judgments cited by the council defending the petition do not improve their case. So these two judgments have been referred by the Union of India, where, my lords, one judgment, that is Sona Chandi, referred to the fee, and that other judgment, Jalkal Vibhag Nagar, that is tax. So there nowhere it is been discussed about the additional fee.
Para 27, you read, para 27.
The
Answers.
Bombay High Court,
My
the
lord.
Bombay High Court has taken into account the fact that the difference between fee for the purpose of quid pro quo
Quid
and
pro
the
quo,
tax, that difference has.
I have gone through that. That is particularly that Jalkal Nigam, your lordship may go through that judgment. That has been clearly, that is regarding tax and fee. So in both the cases, my lords, there is absolutely no discussion about the additional fee. And by interpreting, when the law is very clear, my lord, there is no absurdity or no ambiguity in the law.
All right, so according to you, Madras High Court is correct, Bombay High Court is incorrect.
My lords, I have.
This is your submission.
My lords. I have also prepared a notes of argument, my lords.
Give us.
Which I am submitting copies, my lords. I am submitting the notes of argument, my lords.
Bombay High Court says it is not a penalty, it is to facilitate
Yes.
processing.
Yes.
Because there was no provision.
One
for
case is
extension
left
of
out, my
time.
lord.
So
Yes.
That
this
may
says it
be
is for
listed along with this
facilitation.
case. One case is not listed along with these cases, that is pending, my lord.
So we have heard that also.
I am keeping this number.
Thereafter, after your lordship's order is there, then we are waiting. Thereafter, in cases you will already there, madam.
Yeah, let's say there's one matter on board item 36. In fact, the state was supposed to file some affidavit, but they recently informed us that they will not be doing so. If your lordship can post it after 2 weeks, we'll be ready for the hearing. It will require a written note and everything.
Don't know whether.
Mr. Manthi.
Which item?
Item 36,
6. As requested on behalf of the petitioner.
petitioner. Any date after 2 weeks. Your lordship.
This matter on 2 weeks.
2 weeks.
Item 34 is there. 34 actually the writ appeal government has filed. The other day I submitted that on review application was filed where review has been allowed. So certain things has been incorporated in the original judgment. So they have not filed any writ appeal against that. So they intend to amend, as he was telling me. Government counsel. Khuntia, Mr. Khuntia.
Yes, my lord. during pendency of the writ petition, an order has been passed in that review application. I'll file an amendment to that effect for incorporating that facts in the writ appeal only. Let's give me 1 week time.
And what is the practice here? If an order is passed in a writ proceeding and subsequently a review is filed and the review application is decided, and then a party has to challenge both the orders,
Right.
Yes.
then whether 2 writ appeals are to be filed or 1 appeal.
I'm sorry. Normally, if any other order is passed in that review application, another writ appeal to be filed. What has happened in that? I have seen that review.
No, not in this. I'm trying to just understand the system. Because 1 order is passed in writ proceeding,
Yes, ma'am.
other order is passed in review proceeding.
Yes, ma'am.
So, if someone wants to challenge the order, say passed in review application only.
Well,
So it may be difficult for to entertain that review application if you are not challenging the main order.
well,
If you are challenging both the orders, then whether you are required to file 2 appeals, because in the first case, question of limitation may arise.
Yes.
In the second case, question of limitation may be different. The points, the grounds for challenging the orders may be different. So what do you do? Whether you file 1 appeal challenging the order
They
of
had
review,
already filed 1 writ
No,
appeal.
no, what is usually done, that is what being.
Both the orders to be challenged.
separately, by separate.
Both the orders are to be challenged. Maybe in Supreme Court, actually, we file one.
Forget Supreme Court. We are in High Court, we have our own rules.
So what I beg to submit,
Yes.
Madam, they have already filed 1 writ appeal. Now, during pendency of the writ appeal, the review application has been allowed. So
Then
they have to
what-
file another writ appeal.
no. Here, in fact, I am not challenging this order passed in that review application.
Then don't-
I am
Right?
Why-
If he is not challenging the.
Why I am not challenging, my lord. Only one part of the order, the original order, we are challenging. In that original part, my lord, that honorable single judge had directed to take into account the marks equal in part 1, part 2, part 3. That was the.
We'll see, just we want to know.
Yes, ma'am.
Because see, if we have to decide an appeal in which an original order and an order passed in review proceeding, both are under challenge.
Yes.
Yes, ma'am.
Then
That-
what
yes, ma'am.
course the court should
And
adopt?
I
That
should
is-
examine. I should also examine on this.
So,
I understand. Madam.
Mr. Dale, what do you do?
No, in fact,
But I'm sure you file review applications in many single judge matters and then file a writ appeal. So do you file a single writ appeal or 2?
no, in fact, lordship, my senior is saying, if the review lordship in different context, review is not allowed and the new cause of action has come up, then definitely second writ appeal will come to play, lordship.
Lord, one more small request. I'm sorry, I'm troubling at this hour. Lord, item number 39. There the pleadings are not yet over. My learned friend Mr. Padit is appearing. Yes. So what we are saying is that you taken up 2 weeks after some day, so that the pleading should be completed in the meantime.
Lordship may fix it. I have also filed a petition for vacation of stay also. Lordship may fix a date.
request
The rest of the matters too.
for the parties, list this matter on 2 weeks.
Equity.
So as to enable them to complete the pleading, complete and exchange of pleadings.
Exchange in the meantime.
34, let them take whatever action they want to take.
So,
39 interim order maybe. So 34 are the, I don't know, they are
34, yes,
Next week.
34 next week.
33 2 weeks after my lord.
33, 2 weeks.
Your Lordship, item 33, my learned senior on the last occasion had submitted that they are ready to release the bank accounts.
Release?
Release the bank accounts.
Yes, madam.
Yes, my lord. On process, my lord, that is
1 week.
sinking.
1 week, yes.
1 week.
44 next week.
Your Lordship, the submission may be recorded of my learned senior. Sinking approval
Just
from
remind us.
circle office, my lord, 2 weeks.
All right. She is also taking interest.
1 week, your Lordship.
1 week.
Pleasure.
As requested on behalf of the Respondent. You are respondent or opposite party?
Opposite party.
Huh?
A respondent.
Respondent.
Item 44, item 44.
Next week.
Item 56,
44, 56, 1 week as requested.